হাঁটু লেগে যাচ্ছে। হ্যাঁ, হাঁটু লেগে যাচ্ছে, যাচ্ছে না। না, টাইট হয়ে গেছে অনেকটা। Yes.
Also, may I permit to mention on
Today is not the day of mention.
Your
on
Lordship,
assigned matter?
Assign matter. What you want?
Not in the list.
On Monday. Mention it on Monday.
The trial court had fixed the date on 18th of
Then why you not mention this? The list is proper. You read the list. Today is not the day of mentioning. Friday.
Kindly appreciate that. Lord, kindly fix the matter on it to be mentioned on either Monday or
No, not that. This is a BG court. Two determinations are there. I cannot fix like that. You have to mention it. It was assigned before me on the earlier occasion. I have read out your on entire papers.
Argument was heard and the
I have read out your entire papers, but you have not mentioned it.
kindly
It was assigned at least 15 days ago before me. I have read out the entire paper. Now today you are mentioning that the last day is there. What is this?
kindly appreciate.
Your Lordship, may I permitted to mention one matter for uploading your law
After the heading 2 you mention Monday.
for uploading the order, Your Lordship, which was passed on 25th of July 2025.
Uploaded.
Not yet
What matter?
uploaded, Your Lordship. It was disposed of. I am unable to file my representation, Your Lordship. It is a disposed of matter, Your Lordship.
Not uploaded. How
It
funny.
is not uploaded. We are ready
What is
with
the
our
date?
representation, Your Lordship.
25/7. 25.
Grateful, Your Lordship.
Just wait.
Your Lordship.
25/7. How can it be? Friday the hoche. I was not there since 29. Check it out. Can you? Pending আছে তোমার কাছে?
If to
Yes,
mention
Mr. Nag, what about?
for correction, my lord.
Okay.
Your losses may remember that in the three oil companies matter, the policy in which three repetitions were there. The policy
Okay,
of
okay.
curtailment. The three repetitions were heard analogously. I appear for one of the repetition for Bharat Petroleum. And there is a slight difference in two batch of the matters. In one, there was no.
I know. I know.
But the order, that's why your lordship was pleased to pass a separate order in my writ petition.
Yes.
But unfortunately, my lord, the one paragraph in which there is an extra interim order in reference to the other writ petitions that has also gone down to my. Yes, my lord.
Okay. Very. Monday for correction.
Grateful.
No. Call the list. Dakun.
Your Lordship, I'm appearing for the petitioner.
Yes.
For the state, my lord.
Your Lordship, I'm led by Mr. Ram Anand Agarwal. This matter relates to a vacancy notice. I'm filing my affidavit of service.
Yes. What is the matter about?
Your Lordship, we are fair price owners, fair price shop owners, and our license, Your Lordship, will find at page 22.
How many petitioners? Two
Two
petitioners.
petitioners.
Both of you are the fair price shop owner.
Correct, Your Lordship.
License?
Sorry, Your Lordship.
What is the license?
License is at page 22.
Very good. Then
Your Lordship, and the vacancy notice, Your Lordship will find at page 28.
yes.
So the vacancy notice also relates to the same area. Your Lordship will find central location Baromasia. And if Your Lordship may kindly come back to page 22. The street name also in our license is Baromasia. So it relates to the same street. Lordship, against this vacancy notice, we have sent a representation. Your Lordship will find that at page 34.
Yes.
And at page 35, we have asked for cancellation of the vacancy. Your Lordship, the state has considered this and they have passed an order dated 11th July 2025. And Your Lordship will find that at page 36.
Yes.
Lordship may kindly note the reasons that they have cited for the creation of this vacancy notice. You'll find at third para. Hearing both P1 and P2 taken together, the SCFS told them that the FPS vacancies are being creating following the guidelines so and so in the interest of beneficiaries of a geographical area out of excess beneficiaries from one or more FPS or better serving the beneficiaries so that, and my lord may kindly note that no beneficiary is to trouble large distance to draw ration articles. Your Lordship may know that we are under the Duare Ration scheme. We are making home deliveries. No basis has been made out for this. No complaints have been on record to show that the beneficiaries were having such issues. And Your Lordship, and the para next to it, this third last para on page 36, with regard to FPS vacancy number so and so being the current vacancy notice, it was informed that application process is going on with last date of application 31st July. That period has already ended. Application period is done. The vacancy created by taking around 1100 ration cards from village Baramasiya from P2 and around 1250 ration cards from P1. So they have detagged these from my FPS and then they have created a new vacancy. This is the reason that they have given. Now, Your Lordship may be aware there's the 2021 policy guidelines. Your Lordship will find that at page 38. And page 39 is the policy. If I can kindly place the objects.
Yes.
Your Lordship, so at page 39, the statement, it's basically in the second paragraph, if Your Lordship may kindly note. Your Lordship may start with the first paragraph, if I may just place this, Lordship.
There are other guidelines, page 45.
Yes, so
New
So under the
guidelines, 2023-22, there are other guidelines.
correct. Your Lordship, so in the 2021 guidelines, the minimum retaining ship was 6,500 to 7,500. This was reduced subsequently by the February 2022 guidelines. From 5,000 was the minimum to 6,500 per. And then Your Lordship, 2023 guidelines, which was issued by the director, and this was reduced, and where the
Maybe
retaining
less than 5,000.
less than 5,000. So no minimum was there. So Your Lordship, my humble submission is this is without jurisdiction. This is against the policy. And Your Lordship,
What is your writ petition? What is your prayer in the writ petition?
the prayers Your Lordship will find at page 16. Declaration that the
You challenge the impugn order dated 11th.
He is here, but I have one matter.
Okay.
is the order is issue the challenged. We are asking for writ of mandamus, certiorari, prohibition, and stay.
You challenge the impugn order dated 11th of July.
Yes, Your Lordship will find that at prayer B at page 17. You kindly
Declaration
see.
order dated 11th of February.
Your Lordship will see at prayer B, page 16, it starts, and at page 17, and the impugned order dated 11 July 2025, passed by the Subdivisional Controller, Food and Supplies. This is the order against our representation. We have challenged this as well.
Yes.
Lordship, if I may kindly just submit why this is dehors, the policy.
What is your now? What is the number of DRCs?
We are currently, we are,
Mr. Agarwal, what is the number of DRC total?
That is
6,500 to 6,000.
Only 1250 will be deducted.
Now I want to know
From one
about 6,000.
and 800
Over
from
6,000.
another.
About 6,000.
about 6,000. In these matters, I have taken
Yes,
the
you have
report,
already passed on, my lord, that
detailed report from the state.
my lord, these orders will be passed.
Only difference is
Same water.
24 controller.
24. কোনো motor নেই। Only filing of the report and the matter to appear 3 weeks.
Yes.
As usual, your lordship.
Okay, please take down. Affidavit of service filed on behalf of the petitioner taken on record. Petitioners are the FPS dealers who challenge the vacancy notification dated 2nd of June 2025 issued by the subdivisional controller Matha Bhanga, Coach Bihar. It is the contention of the petitioner that by issuance of such vacancy notification, the central location appearing therein is the area wherein the present petitioners are catering their business. It is the further contention of the petitioner that if new vacancy, if any person was appointed under through the said new vacancy notification, the business of the petitioners would be crunch. Learned counsel for the petitioner also challenge the order issued by the Director DDPS dated 11th February 2022 as well as 28th March 2023, which in the version of the petitioner derogates to the earlier guideline of the state dated 3rd of September 2021. Full stop. He submits that if the impugned vacancy notification is allowed to be continued, the viability of the business of the petitioner would be at stake. Full stop. Learned counsel appearing on behalf of the state raised strong objections and submits that state is on the domain to issue to pass a policy decision for only for the purpose of distribution of recent articles to the public at large, to the beneficiaries at large, not public, beneficiaries at large.
Yes.
Having heard the learned counsel for the parties, in considering the matter involved herein, it appears that in the similar issues, this court has directed the state authority to submit a detailed report. Full stop. I think in this matter, the issue cannot be settled without submission of report by the respondent authority. Under the above observation, the state authority is directed to submit a report regarding the justification of concerned Director DDPS to issue such order for fixing the minimum number of DRCs to be retained by existing FPS dealer. Such report shall be placed within 3 weeks.
My lord.
Within 3 weeks from then, reply by the petitioner within 2 weeks thereafter. Let the matter appear in the list.
My lord, in the
My lord is directing us to file a report in the form of an appeal.
September 1st.
my lord, this matter relates to Jalpaiguri.
Okay.
What I was praying for, let this matter, let the liberty mention to pay for the appropriate bench for hearing.
Okay. Okay, let the matter go out of the list. Parties are at liberty to mention after exchange of affidavit before the appropriate bench having judgment.
My lord, your lordship can record that license has not yet been issued till then.
Okay. No license has been issued.
No, license have not yet been issued.
Yes, that is.
This going on.
ওই কান্ট্রি
And
থেকে the ওই যেখানে স্টেট বললাম
Submits, my lord.
the learned counsel for the state frankly submits that license in respect of the said vacancy notification is yet to be issued. The vacancy proceeding is going on. Right. Okay.
Deeply obliged.
There are 2 petitioners, whether the court fees have filed.
আর
Court fee দিয়েছেন?
হ্যাঁ, দিয়েছি। দেখি না দিলে দিয়ে দেবো।
I'm grateful.
They will not accept.
I'm grateful.
Deeply obliged, my lord.
Next.
For KMD Lordship, led by Mr. Satyajit Talukar, on his leg.
Yes. But I appear for the petitioner.
Milord, very briefly, this is not that matter where Milord, the Kolkata Improvement Trust, it will not put certain block of lands will not on sale. Now, these were will not divided into units and will not prices were fixed. Terms and conditions will not unambiguously stated that it was put on sale. Saleable area was demarcated. Price was fixed. I offered, I was allotted land. I have paid money. Thereafter, my lord, deed has been executed on behalf of KIT as well as, my lord, the petitioners. My lord, query was obtained. Before, my lord, it could be placed for registration. My lord,
Okay, this matter, I understand.
Yes.
I've heard that matter.
I'm grateful. I'm grateful. My lord, there was an amendment in 2017 by dint of which, my lord, the Kolkata Improvement Trust Act and the authority constituted therein, my lord, were abolished. My lord, the KMDA stepped into the shoes of KIT. Now, until, my lord, the date that KIT, my lord, was abolished, KIT acted in terms of the agreement. That is until 2017. The moment KMDA came in and I asked that you execute the deed, now they say that there is a 2012 policy which said that the land blocks owned by the state.
2012 policy of KMDA?
No,
KMC.
state. So KMDA is citing the policy of the state by which even the KIT was bound to say that they can only grant lease and they cannot execute a sale. Now, KMDA, my lord, I say, even by dint of the amendment, which says that KMDA, my lord, owns up all the rights and liabilities. Now, let us go, my lord, to the Civil Procedure Code. My lord, a substituted defendant.
Yes.
In terms of Order 22, Rule 4, Sub-Rule 2, or in terms of Order 22, Rule 10, can take up defense in consonance with the one taken by the original defendant. This 2012 policy was never, my lord, a stumbling block for KIT to act. KIT acted upon it.
Yes.
So today KMD, my lord, cannot take a different, my lord, stand. Insofar as applicability of the policy of 2012 is concerned, my lord, I have cited the division bench judgment, my lord, the bench presided over by Justice I.P. Mukherjee, my lord, where, my lord, the West Bengal Housing Development HIDCO, my lord, was relying on this 2012 policy. Now the court said that these policies will not have any retrospective effect. My allotment is of 2006. My possession has been given in 2007. I have not paid the maximum amount of money even before 2012. Mr. Talukdar said that the entire consideration did not pass on to the seller. Hence, now, my lord, these are, my lord, well decided by statute and by decisions of the Honorable Supreme Court. Lord, kindly sees 53
Paid or partly paid?
partly 53A.
53.
My right stands preserved. Lord, I am tempted, Lord, to cite, Lord, two decisions on this aspect.
Okay.
Because this will, Lord, answer a question of law which my learned friend, Lord, has raised. Lord, kindly, Lord, I am not citing 53A because 53A, my Lord, has already. And the 54 is sale. Lord, kindly, Lord, this is 2020, volume 7, Supreme Court cases. Please. Well, this is 2020, volume 7, Supreme Court cases, page 366.
Yes.
Lord, kindly comes to page 20, paragraph 29.6. 29.6. My Lord would very kindly find that at page 382.
Yes.
But a contract of sale was sought to be denied on the ground that only part payment has been made. The plaintiffs have made out a case of alleged non-payment of a part of sale consideration in the plaint and prayed for relief of cancellation of the sale deed on this ground. Then, my lord, 29.7, my lord, this section 54 sale is defined. But I am not placing this. Then, my lord, kindly sees 29.8, not the last 5 lines starting with the words, the non-payment of a part. My lord has very kindly
Yes.
got it. The non-payment of a part of the sale price would not affect the validity of the sale once the title in the property has already passed. Even if the balance sale consideration is not paid, the sale could not be invalidated on this ground. In order to constitute a sale, the parties must intend to transfer the ownership of property on the agreement to pay the price either in present day or in future. The intention is to be gathered from the recital of the sale deed, the conduct of the parties, and the evidence on record. Now, in this case, my lord, I have shown to my lord that they have executed, my lord, the deed, and the deed was executed in the office of KIT. It was only, my lord, required to be presented
For registration.
for registration. And my lord knows, in terms of section 47,
Yes.
my lord, registration would date back to the date of the execution. Then 29.9, in view of the law laid down by this court, even if the averment of the plaintiffs are taken to be true, that the entire sale consideration had not in fact been paid, it could not be a ground for cancellation of the sale. Now, my lord, kindly sees, my lord, identical, my lord, principle. My lord, this is a little more vocal. My lord, 1999 volume 3 Supreme Court cases. Huh? Kunta. Page 573. Please. Supreme Court cases 573. Lord, paragraph 35. Lord, kindly comes to Lord 36. The definition indicates, the definition of sale
Yes.
indicates that in order to constitute a sale, there must be a transfer of ownership from one person to another person. Transfer of all rights and interests in the properties which are possessed by that person are transferred by him to another person. The transferor cannot retain any part of his interest or right in that property, or else it would not be a sale. The definition further says that the transfer of ownership has to be for a price paid or promised, or part paid and part promised.
Yes.
Price thus constitute an essential ingredient. The word price paid or promised, or part paid and part promised, indicate that actual payment of the whole price at the time of execution of the sale deed is not a sine qua non for completion of sale. My lord, the rest, my lord, is quoted in the Heben, my lord, which I just placed before my lord. My lord, kindly, my lord, see page, paragraph 37. I'm sorry. There is a catena of decisions of various high courts in which it has been held that even if the whole of the price is not paid, the transaction of sale will take effect and the title would pass under that transaction. To cite a few, so and so, it was held that non-payment of a portion of sale price would not affect validity of sale. It was observed that part payment of consideration by the vendee itself proved the intention to pay the remaining amount of the sale price. And in fact, this intention, my lord, has been accomplished. The entire payment has been made and the entire payment was received. So the intention was accomplished. No, what are the bags they are? Excellent. Lord, the kindly sees Lord 2011 volume 13 Supreme Court cases, page 232. 8 and 10 taken out. Lord, paragraph 8, we have bestowed our consideration to the rival submission. Section 53A of the Act, which is relevant for the purpose, reads as follows. Lord, I am not placing this. 53A is quoted. Then, Lord, next page. Lord, kindly sees, Lord, the third paragraph of next page. Then, notwithstanding that, where there is an instrument of transfer, that transfer had not been completed in the manner prescribed, therefore, by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and any person claiming. What remains is only a part of the payment, suppose, is not paid. But if the intention can be gathered that there is an intent to transfer and that has been acted upon, then the transferor, my lord, retains no lien over, my lord, the property concerned.
Yes.
Then paragraph 9, my lord, it causes a post-mortem of the section.
Yes.
From a plain reading of the aforesaid provision, it is evident that party can take shelter behind this provision only when the following conditions are fulfilled. The contract should have been in writing, signed on behalf of the transferor. This is fulfilled. The transferee should have got possession of the immovable property. This is fulfilled. The transferee should have done some act in furtherance of the contract. This is fulfilled. The transferee has either performed his part of the contract or is willing to perform. But he was willing to perform, and in fact, it was performed. So a party can take advantage of this provision only when it satisfied all the conditions aforesaid. All the postulates are sine qua non, and party cannot deprive any benefit by fulfillment of honor. So, this, in effect, is a situation where, had the Amendment Act abolishing KIT not come into force and KMDA not having stepped into the shoes, we would not have seen such a defense being raised on behalf of the respondents, transferors.
Yes.
And KMDA, my lord, at the risk of repetition, I say, cannot, my lord, take a stand either better than or in contradiction to the one taken by KIT, in whose shoes, my lord, the KMDA is stepping in. Now let's see why the KMDA is taking such a stand. That is, my lord, not disclosed in their affidavit in opposition. Lord, since 2021 onwards, there has been, my lord, a shift in the policy of the government. Now the government is saying that we shall offer option to the lessees to convert their leasehold property into freehold, subject to payment of fee. This is happening in respect of, Lord, those allotments where there is a leasehold right.
Yes.
The rate is prescribed. Now the KMDA is falling back upon this 2012 policy and saying that ideally this land should have been granted in lease, and that lease would grant a right to the lessee to apply for freehold and in the process pay some more money to the. So what was agreed upon in 2006 at the time of making the offer is now being sought to be altered with retrospective effect. And that is where, my lord, Rupa and Company, the division bench judgment of our honorable court, my lord,
Yes,
comes into operation. My lord, one decision, my lord, I am, my lord, tempted to cite, that state in contractual field must act with an unbiased, my lord, free and not in an arbitrary or unreasonable manner. The moment state acts capriciously, unjustly, unreasonably, arbitrarily, it is acting, my lord, in violation of Article 14 of the Constitution. A very recent decision, my lord, of the Honorable Supreme Court, that is my lord, that leasehold to freehold, the policy, my lord, which I just cited before, my lord, is here if in the event my lord intends to see this. This is one of, my lord, the documents. The last I is lease tenure eligible for conversion to leasehold, from leasehold to freehold. Now, this is not a case made out by the respondents, but, my lord, I deal it incidentally because I, my lord, suspicious that this could be the only possible reason. This could be the only possible reason. Or else, if the property is being given to me in lease for 99 years, or it is given in perpetuity, how does it really matter for KMDA, who is just acting upon the decisions taken by KIT, and it is not an independent decision of KMDA?
Yes.
My lord, this is, my lord, the decision which I say, my lord, that the state must act, my lord, reasonably and not arbitrarily. This is, my lord, 2024 Supreme Court cases online. Supreme Court 1682. And I invite my lord's kind attention to 1682. Lord, paragraph 51. Paragraph 51 relies on ABL International 2004 Supreme Court with approval.
Yes.
The decision of this court in ABL International, reported in 2004, is significant and was turning point in the scope of judicial review in contractual matters. In this landmark ruling, this court decisively laid down and approved that a relief against a state or its instrumentalities in the matter related to contractual obligations can be sought under writ jurisdiction. The relevant observations read as under. It is clear from the above observations of this court, once the state or its instrumentality of the state is a party to a contract, it has an obligation in law to act fairly, justly, and reasonably, which is a requirement of Article 14 of the Constitution of India. Therefore, if by the impugned repudiation of the claim of the appellant, the first respondent as instrumentality of the state has acted in contravention of the above requirement of Article 14, then we have no hesitation in holding that the writ court can issue suitable directions to set right the arbitrary actions of the first respondent. This is, my lord, the case here. They have, my lord, KMDA today has taken an arbitrary stand. Now, my lord, kindly sees, Lord, paragraph 55. Lord, kindly turn over the page and see I of paragraph 55. My lord has very kindly got it, my lord. The line starting with the words, the mere fact that. My lord has got it, my lord.
Yes.
55 I. The mere fact that relief is sought under a contract which is not statutory will not entitle the state respondent in a case by itself to ward off scrutiny of its action or inaction under the contract if the complaining party is able to establish that the inaction is per se arbitrary. And then paragraph, but kindly skip over the next paragraph. And then again the III, which has a heading exercise of jurisdiction after contract comes into existence. Lord kindly sees, this court has held, even after contract comes into existence, an action may lie by way of a writ to either obviate an arbitrary or unreasonable action on the part of the state, or to call upon it to honor its obligation unless there is a serious or genuine disputes as regard the liability of the state. But I am only saying that I want to hold the state by its promise. State has made a promise to me. I want to hold the state to its promise and perform its obligation. And that, my lord, the writ court can direct. My lord, I am showing this to my lord. Then, my lord, kindly sees, my lord, paragraph 56. What can be discerned from the above is that there has been a considerable shift in the scope of judicial review of the court. I'm sorry. 56.
Yes.
What can be discerned from the above is that there has been a considerable shift in the scope of judicial review of the court when it comes to contractual disputes where one of the parties is the state or its instrumentalities. In view of the law laid down by the court in ABL, Joshi Technology and MP Power, it is difficult to accept the contention of the state of the respondents that the writ petition filed by the appellant before the High Court was not, and the relief prayed was rightly declined by the High Court in so and so. Where a state action is challenged on the ground of being arbitrary, unfair, or unreasonable, the state would be under an obligation to comply with the basic requirements of Article 14 of the Constitution and not act in an arbitrary, unfair, unreasonable manner. This is a constitutional limit of their authority. There is a jural postulate of good faith in business relation and undertakings which is given effect to by preventing arbitrary exercise of powers by public functionaries in contractual matters with private individuals. With the rise of social service state, more and more public-private partnerships continue to emerge, which make it all the more imperative for courts to protect the sanctity of such relations. Or else, my lord, the private individuals would not believe the state. Today you are saying that I will sell you this property
Yes.
for this price. And then tomorrow you resign. I say the state is stopped from saying so. And then lastly, my lord, paragraph 65. What is arbitrariness, my lord, is, my lord, laid down lucidly by the Honorable Supreme Court.
Paragraph
65.
65. Yes.
The meaning and true import of arbitrariness is more easily visualized than precisely stated or defined. The question whether an impugned action is arbitrary or not is ultimately to be answered on the facts and circumstances of a given case. An obvious test to apply is to see whether there is any discernible principle emerging from the impugned act, and if so, does it satisfy the test of reasonableness, where a mode is prescribed for doing an act and there is no impediment in following that procedure. The performance of the act otherwise and in a manner which does not disclose any discernible principle which is reasonable may itself attract the vice of arbitrariness. Here, KIT put the unit on sale, intending it to be sold, executes the sale deed upon receipt of money. I find, my lord, there is no discernible reason for the state to fall back upon a 2012 policy which cannot have a retrospective effect. My lord, I respectfully submit, my lord, kindly direct, my lord, the respondents by a mandamus, my lord, to execute, my lord, to get the, my lord, deed registered and to undertake all formalities, my lord, requisite therefore. The consideration money admittedly has already been paid to the respondent's predecessor, KIT.
Yes.
I am grateful to my lord. না না নতুন কিছু নেই, তোমার কথা উত্তরগুলো দিয়েছি।
May I?
Why? Reply again, reply.
There cannot there cannot be
Yes,
any
Mr.
reply
there
to
cannot.
reply. But may I remind your lordships only
Yes.
one or two aspects what I argued. My lord, there is no clash with the proposition cited by my learned friend. But here the question is, if even assuming is not the KMDA was merely substituted by virtue of amendment, the amending act has been annexed with the pleadings. At 116, Lordship will find the notification by which the Town and Country Planning Act, Section 27 was amended. Thereby, Miller repealing the act, KIE Act, by which Miller the KIT was constituted. And thereby, upon such merger and by way of amendment, all rights and liabilities, powers, and whatever that bestowed upon
Yes.
the KMD. KMD is, it's true, steps into the shoes of
James.
KIT.
KIT.
KIT. Here, it's a fact. We are not denying that the KIT had proposed to sell it
Yes.
on outright basis. And on certain terms and conditions, the payments was scheduled to be made. Unless and until it was, Milord, I am not adding anything just to refresh your.
Oh, my
Lordship's mind.
memory never fails, my lord. My lord takes
For my
takes
satisfaction,
notes painstakingly.
that there was a condition, the schedule of payment was made. The petitioner completed payment in 2013 after the policy came into being. That was my argument, that the before policy came into being, the right of the petitioner was not crystallized.
No, I understand. I understand your submission, but these are the submissions from the bar. What is the stand taken by the KMC or KMDA? After the entire rights, liabilities, assets of the KIT has transferred to the KMDA,
Yes.
legally you have to act according to the promise of the KIT with the public
That we have
individuals.
answered in our affidavit.
Yes, I will look into that.
In our affidavit, we have answered that. That Lordship will consider that aspect.
Yes,
But
yes.
after the merger, the KMDA came in picture, and KMDA as a parastatal of the government and under the administrative control of the state is bound by the policies taken by the state and directives of the state. There it is specifically directed in that 26 December 2012 policy that government and its parastatals can only transfer by way of lease of 99.
Very good. Hard.
I'm grateful, my deeply obliged.
Okay, argument on behalf of the parties concluded. Made CLE.
Grateful.
জাজমেন্ট গুলো আর এই নোটসটা সব আলাদা করে রাখবে হ্যাঁ আমার না একটা ফাইল করতে হবে। হ্যাঁ ঠিক আছে নেক্সট
Time for the petitioner, my lord, in 7138.
20
I'm filing my reply, my lord.
আমার এবিটি
I'm for the state, my lord, led by Mr. Sopul.
What is the affidavit in opposition?
My lord, my affidavit in opposition, my lord.
No, state has not yet filed any opposition to my writ petition, my lord. But I am praying for extension of the interim order, my lord. By virtue of interim order, my lord, I am continuing with the business, my lord. Your lordship has passed the interim order on 4th April, my lord.
My lord, in this matter, my lord, I am for the respondent number 5 in and in second matter, I am the writ petitioner.
You are the writ petitioner. You are the old writ petitioner.
I am the old. And my lord, in my matter, there is an interim order. In violation of that interim order, his appointment was granted. I filed a contempt application. His license was cancelled. and he filed an application for addition of party. Your lordship was pleased to allow his application. I preferred an appeal.
We went up to the honorable division
Let
bench.
me clarify.
Division bench has,
আমাকেও একটু বলতে দিন।
I know that the division bench has set it down
Yes.
and giving him the liberty to file a writ
My-
petition.
My lord.
Yes.
And my lord,
Filed a
my
writ
lord,
petition.
no contempt has been filed against
Just
the
wait, Mr.
notification.
Paul. Just wait, Ms. Paul.
And thereafter, my lord, the division bench that he is neither a necessary party nor a proper party. Also viewed that his right would crystallize after vacating of interim order.
Yes.
And that was only an observation, my lord.
And
That's
on the second, on the matter was adjourned for 2nd April. And in the meantime, my learned friend filed an writ petition. And in this writ petition, this appeal also direction there was had the matter to writ petition analogous.
Are both the matter analogous?
Analogous. And my lord, but your lordship was pleased to pass this interim order, and challenging this interim order, I preferred also an appeal. And this appeal is running in the list of their lordships of presiding over Honorable Justice Devanshu Bhasak, and matter will be heard either 1 or 2 days, my lord. And so my submission is, my lord, if your lordship intend to extend the interim order, fix it for a short period, both the matter are ready, matter may be heard.
That's
and
why
am
I want
summering
to,
for
I want to
2040.
hear both the matters. I want the affidavit.
My lord, I am in default, my lord, I am told, my lord, I am in default. Lordship gave us 2 weeks time on 23rd of July. Well, it is, let there be an extension of time, that time, my lord, for a few days, my lord. করতে পারবে?
Ready?
My lord, in this matter, my lord,
Affidavit ready?
No, not ready, my lord. Lordship can extend the time for, my lord, a short time, 10 days time be given. I'm sorry, my lord, that this is very embarrassing.
Okay.
14 matter, my lord.
So, your writ petition is
Your matter
WPA
is 2000, but mine is not
71838 of 2025.
My
718
of 2025, my lord,
This
I
matter
applied
you
my,
want to file the affidavit.
Yes,
And your matter affidavit has
Ready, ready,
all
complete, my lord.
complete.
All the pleadings complete.
my lord, I'll do it, my lord, within 10 days, my lord.
So I am fixing the date of hearing. In the meantime, you file the affidavit.
Yes, my lord, yes, my lord.
Today we are running 8th.
वो तो साबित प्रिपेयर नहीं कुछ है जानिए ना
Second September, 2nd September.
this is from the
কিছু নেই 2nd September 2 p.m. I am fixing the date of hearing.
2nd September 2 p.m.
Affidavit within 2 weeks. Reply if any by the prisoner within 1 week.
my
Please
lord,
take down.
kindly extend the interim order.
What the time will be extended by?
No, no, I am fixing the date for peremptory date for hearing and particular date, particular time, so that the hearing can be done within the meantime.
My lord.
Today I also can heard the matter, but the affidavit is not there.
No,
That's why the.
I'm so sorry, my lord, I'm very embarrassed.
Okay,
my lord.
okay, okay.
কি বলবো আমার সাথে?
আপনাকে বলেছিলাম আমি
লেখো
তিন লাখ আমার কোনো
state
assistance নেই।
was directed to
Government
file
assistance
affidavit
করে করবো।
in opposition in connection with WPA 7138 of 2025. Next para, learned counsel, learned senior, Mr. Dotto, Shapon Dotto, learned senior counsel appearing, learned senior counsel and AGP appearing on behalf of the state, 6 accommodation for some, for 2 weeks to file affidavit in opposition. Accordingly, let the affidavit in opposition by the state be filed within 2 weeks, within 2 weeks since. Reply if any by the prisoner within 1 week thereafter. Full stop. Next paragraph. As the matter, as the matter,
September.
along with as the matter under direction of the honorable division bench to be heard analogously along with WPA 6527 of 2014, I think it necessary to fix a particular date and time so that the matter, so that both the matter can be heard effectively. Accordingly, list the matter on 2nd of September 2000, list both the matter on 2nd of September 2025, peremptorily at 2 p.m. for hearing of both the writ petitions. Full stop. Next paragraph. interim order passed by this court on the earlier occasion in WPA 7138 of 2025 be further extended till 9th of September 2025 or until further order, whichever is earlier.
I'm grateful.
Affidavit in reply on behalf of the petitioner.
Against the opposition filed by me.
Against the affidavit in opposition
Filed by the
filed by respondent number 5
Five.
be taken on record. Affidavit in reply in connection with WPA 7138 of 2025.
I'm grateful, madam.
Next.
Six minute I appear. Only one prayer, man. Contempt application number 808 may be taken and record. Got on the record.
And all the
Contempt application is not listed,
Not one.
is not in the list.
Not in the list. What is maybe brought down from the section. File is lying in the section, my lord.
application, their application.
Your lordship direction is necessary, my lord, to bring the record, my lord. All the application for division bench direction is to heard all the application, including the
What is
petition.
the number?
808, my lord. CPN 8.
State has also filed the application for modification in their petition matter. But so many, all the applications be listed together, so
Yes,
that
my lord.
effective hearing can be given.
Yes, yes.
Okay.
Well said.
Office is directed
Canton,
to
contempt
place
and
all the applications, including contempt applications, in connection with both the writ petition on the urgent date.
Madam, I'm
That will suffice. Yes, item number 6.
Yes, 6 minute I appear for the petitioner. Item 6 to 10, Lordship Lord, are similar matters, my lord, where similar questions of law are involved.
6 and
6 to 10.
6 to 10.
In fact, my lord, in all these writ petitions, my lord, I had applied for amendment, and your lordship allowed my amendment applications pursuant to your lordship's orders, all dated 4th of July 2025. But I'll come one by one. If lordship takes the first matter, item 6, writ petition 23427 of 2006. But there, my lord, we filed an application Can 2 of 2025, which was allowed on 4th of July 2025.
Application for amendment being Can 1 of 2025.
My lord, Can 1.
Can 1 is the application for restoration.
No, my lord, Can 1 was for restoration, which was allowed on the earlier occasion.
Okay.
Post restoration, we applied for amendment of the writ petition by filing Can 2. Can 2 was allowed by your lordship on 4th of July 2025.
Okay.
Yes, now, my lord, we have filed the amended writ petition. We have also served the
Have you
state.
served it?
Yes, my lord, one. সাজানো আছে.
Item 6
আচ্ছা. But so far as item 6 is concerned, writ petition 23427 of 2006, it has been served. We have served the state, the respondent numbers 1 and 2, as well as, my lord, we have implemented HITCO, the respondent number 3. HITCO has also been served. ঠিক আছে, French direction দিয়ে দিন.
Where is the amended copy of plaint? Commended copy of writ petition?
It has been filed. It has, I think it
It is filed?
Yes, it has been filed.
Order over, they have tagged it.
Amended writ petition. Okay. Affirming the same. Very good.
Yes, if lordship will kindly see page 3 of the amended writ petition, My lord, now, my lord, West Bengal Housing Infrastructure Development Corporation Limited, that is HIDCO, is now a party. Because in the proposed amendment, my lord, we had impleted HIDCO.
Very good. Please take down. In pursuance to the order dated 4th of July 2025, the petitioner has filed the amended writ petition after affirming the same. Petitioner, no, next paragraph. Affidavit of service filed on behalf of the petitioner be taken on record. Stop. It appears from the affidavit that copy of amended copy of writ petition has already been served upon the respondents, including the added respondents. Within bracket, HIDCO. Considering the same, it appears that petitioner has perfectly complied with the direction of this court, VD order dated 4th of September, 4th of July 2025. Who is appearing for the state?
Well, Mr. Dey was appearing on the.
Okay. Hence, since the petitioner has placed the amended pleadings, the state authority is at liberty to use affidavit in opposition, if any, against such pleading. Within 2 weeks hence, 2 weeks, within 2 weeks hence, reply, if any, by the petitioner.
Fortnight to file.
Within 2 weeks thereafter. Let the matter go out of the list. Parties are at liberty to mention after exchange of affidavits.
If a date, it's a 2006 writ petition, only one request to your lordship, we assure your lordship that we will not take any extension to file the affidavit and reply. Let the state file it within the time specified by your lordship. 2006 writ petition, if it can be heard.
If any they want to file, if any, already affidavit is there.
If they do not file, the
If
matter
they
ends,
don't
it
do,
can be heard.
we can proceed.
But only thing is,
So you mention it.
if lordship can make it a peremptory, so far as the time.
No, I have given that 2 weeks. How peremptory?
Very.
Each and
Lordship,
every
kindly
order
make
of
the
the
matter
court is
returnable on
peremptory.
any day.
Yes.
Not kindly direct the matter to returnable any day for hearing of the writ.
No, you mention it after exchange of affidavits. It would be better. Next.
My lord, I am for the writ petitioner. My lord, this is a similar matter, my lord. The same order may be passed, my lord. Similar matter.
Have you placed the amended copy of writ petition?
Yes, my lord.
Where is the
Maybe
affidavit
go-
of service?
My lord, fine.
Similar direction.
Grateful, my lord.
Next.
But item number 8 and 9, the same directions could be passed. The affidavit of service in item number 8, the 23429 writ petition number. I'm filing the affidavit of service. I see that it has come up for correction in the cause list.
Affidavit is in. Why appearing for correction?
No, appearing for this.
Perhaps erroneously appearing. Can you correct?
Look, in the cause
Just-
list, there's an endorsement just below the writ petition number.
Cause title.
Yes.
That's there.
But now I see the cause title will stand as Sushila Saraugi and others was State of West Bengal and others. So possibly the old cause title
Okay,
is.
okay.
Well, Rajkumar Saragwi was the petitioner number 1 who had passed away. The name has been struck off. As pleaded in my amendment application, your lordship had allowed that.
দেখুন আইটেম নম্বরগুলো তো চেঞ্জ কোনটা কত 6 7 8 আমাদের কিছুই না
So your amendment application is can 2.
Yes. That had been
That is
allowed.
correct.
We had
Can 2 or can 3?
Can
Can 3 is
can
the
3
restoration.
possibly in this matter.
No, can 3 is the restoration, I think.
can 2 is the restoration এর আগে একটা
এখানে কি করে
হ্যাঁ
বলবো?
এটা
একটা
তো দুখানা ছিল
Yes,
can
yes.
3 is
Can 3 is the
amendment.
amendment.
Can 3 is the amendment.
can 3 is the
Yes. Possibly your lordship will kindly refer to
Because can
4th
1
of
will-
July order.
can
Can
1 was
3
the
is the
restoration section 5 and this is the third
Can 3 is the amendment of writ petition application.
এটা তো ছিল না যেটা রেস্টোরেশন সে 48 টা তো 2 হবে 47 এ 1 2 বাকি তিনটেতেই 3
This matter appears for
Other directions could be seen.
correction and necessary order. Full stop. In can 2 was the restoration.
yes
Yes.
Yes.
No,
in-
can 2 was the condonation. Can 1 is the restoration and can 3 was the amendment application.
Can 3, what is the can 2? Can 2 is
Can 2
section
is
5.
the condonation of delay.
Section 5.
Yes. With respect to the restoration.
24.
Your lordship will once kindly refer to the 4th of July order.
I've
Your
seen
lordship.
the order, but there is some error in the order. That's why I'm checking.
initially restoration file question then they took a point they have to take out a section 5 so abundant person we took out a section 5
Lekho. In the order dated 4th of July 2025, in the cause title, the can number should be read as can 2 of 2024 instead of can 2 of 2025. Full stop. In page 2 of the said order, in the last line of the first paragraph, the can number should be correctly read as quote unquote can 3 of 2024 instead of can 3 of 2025.
Possibly your lordship.
Can 2.
Yes. Can 2 of 2024.
Can 2 of 2024 instead of can 3 of 2025. হবে হচ্ছে can 2 of 2024.
Sorry to interrupt, Millard.
2 of
This will possibly be can 1 of 2024 at page 2, first paragraph. Because your lordship will refer.
Restored the instant writ petition by allowing application being can.
The restoration application was can 1. We had filed. Then the other side had
Okay,
taken a point of section 5. That is can.
That is okay. Can 1 of 2024 instead of can 3 of 2025. Three of 2025. 3 of 2025 টা আছে দুটোই কোট আনকোট ঠিক আছে তারপরে সিমিলার অর্ডার there are similar parties are liberty to mention 2x 2x.
Yes. Let item number 9.
Item number 8. Okay, you give a name. Again, same error.
Yes. May I file the affidavit of service
Yes.
in item number 9? Title correction টা বলো তো। পরেরটা 10
This matter appears under the heading of correction, under the heading correction, and for necessary order.
है ना?
Full stop.
correction
In the
করছেন
in the order dated
necessary order.
in the second page
for correction and necessary order.
of order dated 4th of July 2025. Last line of the first paragraph. The can number should be read as can 1 of 2024 instead of can 3 of 2025. Then. Okay. Similar direction.
With item number 10 also, they're filing the affidavit of service. Similar directions could be passed, my lord.
এই যে 10 এটা 10 affidavit of service.
Affidavit of service টা দিয়ে দাও।
4742
7 টা আছে।
47 এ কোনো প্রবলেম হওয়া উচিত না।
47 হয়ে গেছে।
হ্যাঁ, কি আছে? এটা তো অসুবিধা হওয়া উচিত, কারণ এখানে একটাই ক্যান।
Similar direction, similar correction.
First can
Can 1 of 2024 instead of can 3 of 2024. আগে যে অর্ডারটা হয়েছে same order. Similar direction 2 weeks 2 weeks.
2 weeks 2 weeks.
Very grateful.
এগুলো কি চলবে হবে না? Nothing else anyway.
Grateful, my lord.
Call next matter.
My lord, I appear for the petitioner and 40 added petitioners, my lord. Unfortunate on the part of the petitioners, my lord. After hearing on 14 January 2025 before the Honorable Justice Patnaik, the matter was scheduled that everything is completed. Only written notes of argument, my learned friend asked the will division, and we are also prayed for it. This only said the matter was change of determination. Come to the Mr. Honorable Justice Rai.
Aniruddha Rai.
Thereafter, before your lordship. In the meantime, we have mentioned before your lordship, allowed the mention, and we have searched the department, nowhere is filed. Thereafter, without disturbing this honorable court, we made an application before the register, the lodgement matters.
For reconstruction.
No, only for find out the file and send it to the honorable justice. And thereafter, when the department is unable to supply the file, thereafter we made an application for not made it a verbal oral submission. Kindly allow the reconstruction. Then I have been advised to mention before the lordship. The matter was mentioned by Mr. Lahiri, and thereafter matter came on the list tomorrow, my lord, and today also continue. My respectful submission before lordship. The petitioners are suffering since 2012, and so many times file has been missing, coming, going, whatever maybe, my lord. I have never allegation. No one. Only my lord praying to the lordship for pass an order for reconstruction so that it can be heard.
Yes. You are for the?
I'm for the Asansol Durgapur Development Authority. See, but matter was hard considerably. How can the file go
How
missing?
the file is missing? Very
And I have
decent.
also made an application
So
before.
the
But-
file was there before Justice Rai.
I understand sometimes it's happened, file gets destroyed, reconstruction is required.
New matter, running matter, how the matter can be?
It was listed in February, I believe. February মাসে ছিল দাদা।
Yes, Mr.
So when the matter was last appeared before the coordinate bench?
14 January.
14th of January 2025.
25, yes, my lord.
And the department received file on
My lord, the file was also missing in between 2018 to 2025, my lord. 23.
the department section received the file from the court on 30th April 2025. This I have corrected through my clerk. The department says the file was received in the record, but thereafter file is not.
File received
by the mandamus department 30th April 2025. And thereafter
30th April
2025, 2025.
The mandamus section has received the file on 30th of April.
My lord.
It is as per.
So
My lord, I was.
on inquiry I came to know, but I have no authenticated documentation.
So where is the file now? Mandamus section.
My lord,
There.
This is my
my lord, I spent hours together in the mandamus section. They said a lot of files is missing, which was received on that day. And till date, I was there so many times. They are only sending report. The file is under search. Similar thing, my lord, happened in between 2018 to
Is there any
2023.
communication between your applications to the section like that? Can you place those? Can you place those applications which you made to the department?
Register. Before the register.
Very good.
And the same was with the department also.
No, order sheet করুন। This matter appearing in the list after mentioning by the petitioner. Full stop. It is submitted by the petitioner that initially the matter was heard by a coordinate bench having determination. Full stop. Argument of the parties are nearly completed. During that period, due to the change of determination,
The data, my lord, last date of order was 14th January 2025, which was recorded.
completed. Full stop. Nearly completed. Semicolon now. During that period, due to the change of determination, the matter was go out of the list. Full stop. Go out of the list of the said coordinate bench. Full stop. It is contended by the petitioner, learned counsel for the petitioner, that lastly the matter appeared before the coordinate bench having determination on 14th of January 2025. It is the further contention of the petitioner that this court having determination to hear out the matter. Full stop. The petitioners has mentioned the matter before this court, and this court has allowed the mention, but the file could not reach before this court. Full stop. The petitioner has personally inquired to the department regarding the whereabouts of the file, but the concerned department has informed that file is not traceable. Full stop. The petitioner has learned counsel for the petitioner, learned advocate and record for the petitioner, has written a letter to the learned register administration within bracket Lozima and OM bracket close. Appellate side, High Court, Calcutta, on 19th of May 2025. The concerned registered could not answer satisfactorily. Hence, the matter appeared before this court. Full stop. Having heard the learned, no, I have also heard the learned counsel appearing on behalf of ADDA, as Asansol Durgapur Development Authority. Learned counsel for ADDA, a respondent, submits that the argument has already been started. Considering the peculiar situation of this matter, it appears to me that to ascertain the true nature and circumstances of the situation and the whereabouts of the record, it is necessary for the concerned department to submit a detailed report. As the matter is pending since 2016, nearly a decade has been passed. Thus, I think it necessary that learned register administration within bracket L and OM, Appellate Side High Court, Calcutta, must submit a report regarding the whereabouts of the record within 10 days from date. Let the matter appear in the list on appear in the list on 19th of August 2025 under the same.
Milord, with your leave, I like to mention that Milord, ADDA has completed its argument. As per the order, I can place it before you that on the 14th January order.
Let the record be passed. Let the record be appear. Thereafter, I will pass the necessary order. Let a report be submitted.
Lordship.
Under the same heading, I make it clear that this order shall not prevent the concerned department. This order shall not prevent the concerned department to produce the record before this court. Much earlier to the urgent date. Okay.
এখানে আপনি বলছেন কমপ্লিট আবার ওখানে বলছেন আপনি এখানে বলছেন যে কমপ্লিট হয়েছে ওখান থেকে বলছে আবার রিপিট
না নতুন জজের কাছে তো আবার আর্গুমেন্ট করতে হবে
No, Milord, your lordship agreed to release the case on our submissions before your lordships on the last day. That all hearing were completed as it is evident from the order dated 14th January 2025.
Let me find the record, sir. Thereafter, I will pass the necessary order.
Lordship.
How can a record be not traceable? Running record.
Similarly, it was there between 2018 to 2023, Milord.
No. Let me find out what is the reason there. I want the report from the register. Next.
Much obliged, Milord.
My lord, I am for the petitioner. My lord, last occasion, my lord has extensively heard this matter, my lord. I was placing where KMC has taken my land, but not admitting that fact.
Yes.
In the previous round of writ petition, there was a direction passed by Justice Dotto and subsequently passed by Justice Ashok Das Adhikari. My lord, that I'll be placing, my lord, kindly come to the previous round of litigation, my lord, which is at page. Writ petition starts from page 52.
Today, why it is appearing under heading to be mentioned?
Why under today? No, it is Pathan.
Yes. It's parted matter. Very well, you continue.
No, they are avoiding. Last occasion,
Mr. Ghosh, Alok Kumar Ghosh is there.
Yes. And Mr. Ghosh's junior was there. Now kindly come to page 55 of my writ petition.
page 52, the WP number 24944 of 2007. My lord has got
Yes.
it. Yes. Now, my lord, kindly come to the pleading portion. My lord, I'll be placing. Your petitioners are the joint owners and in possession of the land measuring about 21 kathas, more or less, jail number 33, Mouja Raipur, RS Dag number such and such, RS Khotiar number such and such, Police Station Jadavpur, South 24 Parganas, Kolkata, Ward number 101, Bodo 11, here to annexed such and such. Your petitioner number 2 is aged about 85 years and your petitioner number 1 is aged about 57 years. The said premises was originally owned and possessed by Madhusudan Guha till he died on 20th April 1983. And I have shown the name of Madhusudan Guha. My learned friend has come. Is annexed here to marked P2. The said Madhusudan Guha died intestate, leaving behind him your petitioner number 1 daughter and petitioner number 2 wife as his heirs and legal representative on whom the ownership of the property devolved. With the death of Madhusudan Guha.
Yes.
Immediately after the death of Madhusudan Guha, your petitioners through their representative duly approached the KMC, the respondent number municipal authorities to mutate their names as owners of the said premises and for raising property tax bills in
Yes.
their names. So property was unassessed. So as soon as the petitioner's present petitioner's predecessor approached the concerned office of the municipality without any valid reason, illegally refused to entertain any application, did not even accept the application. Any application for mutating the names of your petitioners in respect of the said premises. And your petitioners' representatives were asked to apply before the BLLRO, Thakurpukur, Metiabruj block at Kosba, Kolkata, respondent number 6, for mutating the names of your petitioners and to obtain no objection certificate from them. And thereafter, your petitioners' names may be mutated in the records of assessment book of the municipality in respect of the said premises. Accordingly, your petitioners, not being aware of the legal position applied before the additional block land and land reforms officer, Thakurpukur, Metiabruj at Kosba, but without any fruitful result, till date, your petitioners' names have not been mutated by any of the respondents. Reference will be made to the copies of the said applications for mutation if and when necessary. Then 5. In view of the directions given by the appropriate authorities of the municipalities, your petitioners to avoid complications had regularly paid the rent of the said premises and the office of the concerned land reforms department received and duly acknowledged receipt of rents from the petitioners and issued receipts that the said Madhusudan Guha died and that your petitioners are his heirs and legal representatives.
Yes.
Then para 6. The petitioner said premises is situated within the area and boundary of the KMC described in Schedule 2 as ward number 101 of Jadavpur constituency, which at all material times had and presently as an elected councillor such and such. Then municipality is statutorily bound to register and mutate the names under section 183 subsection 5 of the KMC Act 1980. This honorable court should issue a mandamus directing. That was my cause of action.
Yes.
Then, well, kindly come to para 7. In the past, on 1 or 2 occasions, at the request of the municipality, your petitioners, without conferring any right or interest, accorded temporary permission for few specific dates and permitted them to utilize a portion of the said premises for holding book fair fee free of cost. After the fairs and exhibition were over, the concerned persons duly vacated the entire premises as arranged, and till today it is lying vacant without any encumbrances. Your petitioners state that all along the said persons and our authority, the respondents, knew and had due knowledge that the petitioners had independent right and status as owners of the said premises. Then, para 8. Recently on October 8th, 2007, your petitioners were surprised to learn that some persons, along with some officers, men of the municipality, are trying to dig and excavate soil from some portion of the said premises. Then para 9. Though further inquiry was made, the said persons and officers refused to disclose their identity and any information. Your petitioners are not aware of initiation of any acquisition proceedings relating to the premises, and no notice under any law has been affixed at the premises, tendered, or suffered on any of your petitioners till date in respect of the said premises. Your petitioners strongly believe in the facts and circumstances of this case that if any notice has been issued or notification published, the same must have been done in the name of Madhusudan Guho, who as stated died as far back in 1983. And in that event, the notice on notification that may have been issued for taking possession of the said premises for acquisition for any purpose is wholly illegal or void ab initio. Your petitioners, in spite of making inquiries, could not. So 2007, when my writ petition was on board, that time I took the point that there is no acquisition notification. Nobody has ever issued any notification under Land Acquisition Act, or any authority has ever claimed that particular property has been acquired. Were trying to encroach upon by the petitioner said premises. Who are your petitioners, in spite of making inquiries, could not ascertain under what law or authority the municipal officers and their men were trying to encroach upon the petitioner said premises. The respondent authorities should be directed to produce before this honorable court all informations and records, including the formation of opinion, if any, scheme that may have been framed, or any decision taken or order passed on the basis of which the respondent started threatening to interfere and encroach upon the petitioner said premises, assuming but not admitting that the respondent authorities had taken recourse to the provisions of Land Acquisition Act 1894. Then in that event, it is mandatory to serve notice on your petitioners before entering the said premises or for digging or for any other purposes. Then that 10 is relating to club. Suit. Club is gone. So now municipality হেরে গেছেন ওটা দিয়ে ঢুকতে পারবেন না, সম্ভব না।
Yes, what happened in that writ petition?
Now kindly come to page B. ঢুকতে পাচ্ছেন না, ঢুকতে পাচ্ছেন না ওরকম ভাবে। Page 66.
Prayers. No, what is this?
Kindly come to the prayer portion. That the entire B, that a declaration that the entire acquisition proceedings, if found to have been initiated at all, we were not aware, initiated by the respondents, and all orders passed and decision taken in connection with the said premises in that regard are honest, and all actions and steps taken by the respondents for acquisition and or taking possession of the petitioners said premises are illegal, void, and liable to be struck down.
So why you made a declaration when you do not know the acquisition proceeding is there?
For abundant precaution. For abundant precaution.
Very good.
Let us, I'll take your lordship to the order passed.
Yes, what is the order passed?
Now, kindly come to prayer C also.
Mandamus.
They are a writ such and such mandamus do issue restraining the respondents, their servants and agents not to disturb or interfere with the possession of the petitioner's premises comprised in jail number such and such, police station such and such, 101, in the guise of purported acquisition or any proceeding. Now, my lord, kindly come to the first ordering portion, that is page 83. Ah. 29th November 2007.
Yes, page
83.
83.
Hmm.
Yes.
List this writ petition in the combined list of December 2007 under the heading motion. Mr. Ghosh, Learned Counsel for the corporation shall take instruction as to whether the corporation intends to utilize the lands mentioned in paragraph 1 of the petition in any manner or not. Kindly mark it, that part.
Yes.
Now, kindly come to page 88.
Yes.
This is the final order. Mr. Chakraborty, Learned Counsel, appearing for the petitioner, submits that the petitioner's father was the original owner of plot of land measuring about 21 kathas, and after her father's death, her mother and petitioner number 1 was the co-owner and made an application for mutation of their names before the municipal authority, but the municipal authority did not accept such municipal application. They were to file this writ petition against the inaction or non-action on the side of the respondent authorities. Then Mr. Chakraborty submits that during the pendency of this writ petition, her mother died and she is the sole owner of the property, and then such and such. Then third paragraph, they submitted that the respondent authorities did not accept the mutation application submitted by the writ petitioner. Then Mr. Ghosh, Learned Counsel, appearing for the municipal authority, submits that the petitioner's property is not numbered and also not assessed, since the municipality do not have any unassessed and unnumbered property in the area. No action could be taken by municipal authorities. Even then, municipality did not come forward and say no property has been vested into the KMC. Never. That was specifically stand taken by the KMC that property was unassessed, unnumbered, hence it did not get the place. Then heard the Learned Counsel for the respective parties and considered the materials available on record. It appears that the writ petitioners are claiming ownership in respect of the property in question, and nobody is claiming any title over in respect of the property in question. So all the respondents involved in the previous writ petition never ever claimed that property got vested in favor of state or property got vested in favor of KMC. Now, kindly come to the next paragraph. Therefore, the municipal authorities are directed to accept the mutation application to be filed by the petitioners within a period of 4 weeks from date, and to consider dispose of the same in accordance with law, giving an opportunity of hearing. Thereafter, we filed. Municipality did not do anything. They kept the matter pending. Then this present round of litigation started. This cause of action, they tried to put lamppost, which they have been doing it. They have been utilizing it as park. Now, I'll take your lordships. Now they are stand. What is...
So your application for mutation was not accepted?
No, still pending. Now they have rejected in 2025. Now, the present writ petition was filed. What was the reason for application of this writ petition? Now, kindly come to the pleading of this present writ petition once. What was my prayer? Since they have been utilizing my land, occupational charges be then ask them to reinstate if they prayer is C is order or directions, thereby commanding the state respondents to reinstate the petitioner's land to its original position by removing the KMC signboard from the petitioner's Rayati land and pay the occupational charges if the authority is not willing to acquire. Either they must go for acquisition, and since they have been utilizing this land for their own purpose, then they must pay the occupational charges.
Who are you?
I'm the landowner.
Petitioners? No other names are Jahangir Das and Tulu Das?
Yes.
Who are you? The matter was heard by the earlier by Pratima Das, daughter of Madhusudan Guha.
Kindly come to page para 11. Perhaps my lord is
Yes, I want
10 and 11. My lord will get the tree, genealogical tree.
Pratima Das died.
Yes.
Okay, that's why. So you are the sons of the Pratima.
Yes.
Okay. Yes, proceed.
That's it.
Yes, proceed.
They even tried their level best to question who am I. Then they were unsuccessful. Now, Manat, kindly come to the present. Amar affidavit ta koi. Now, how dubious stand been taken by an Article 12 authority just to exploit a citizen's property without paying acquisition, without paying the cost of acquisition? How they are dodging the court? Manat, kindly come to. Kindly take their two reports filed on 13th December 2023. Two reports, one supplementary affidavit. Manad will find two reports.
Yes, I found.
Report in the form of affidavit on behalf of respondent numbers 5 and 6. Malad has got it.
12th of December.
12th of December, and one is 13th of December.
And another one affidavit in opposition.
Malad, I'll come to that affidavit in opposition later.
Two reports.
Two reports. Malad, kindly come to para 2 and 3. Para 2 is only mere quotation, quoting that was the order passed, and on that basis this report is being filed. Then 3, it is stated that in compliance with the order dated passed by this honorable court in connection with the earlier writ petition, respondent number 5 has issued hearing notices. 2007 order was passed. They were issuing notice. So they were saying that they did right thing. So they have issued hearing notices to the petitioners, and hearing are held on various dates wherein the authorized representative of the petitioners are representing them before the assessor collector. So and so forth. Then, Manat, kindly come to the annexures. Several notices of 2023. They were so diligent, they could not do it. From 2007, they have issued these notices. Now they tried they tried to see through that how they can take the point of locus or take the point of all flimsy grounds. That is, my lord, will find at page 12. Kindly come to page 12 of that report. Matter discussed, but it is found that the none of the owners have appeared. Rather, Sri Rajesh Rai, advocate, came with one registered general power of attorney dated such and such, and Mr. Brahmachari Nimohi Chaitanya claiming that he is representing both of the applicants. After prolonged discussion, it was advised to them to come up with the due authorization along with all documents as discussed. As I said, well, they tried to even take the flimsy grounds how to delay the hearing proceedings. Still in force by the applicants, the next date of appearance is fixed on 29th of November 2023, Wednesday at 12:30 p.m. at AC chamber, such and such. Then, my lord, kindly turn to the page number 13. Then quoted about the power of attorney of Jahangir Das, power of attorney of Brahmachari Nimohi, then deed of Madhusudan Guho, Porcha of Madhusudan Guho. They could not do anything about that, because other mutating authority has recorded my predecessor's name, and there is a Porcha in favor of that. So they could not bypass that. Now, I kindly come to the bottom portion. Since the matter is being under process on the direction of the Honorable Court, as well as the quantum of land to be assessed, mutated, is around 20 kathas. Hence, assessor collector is of the opinion that personal appearance of the now first day power of attorney holder. Then the quantum of land is beyond 20 katha. So personal hearing is required. Bring both the persons of the applicants along with proper ID will be prudent to deal the matter without any difficulty, and the same was conveyed to Mr. Pradeep Sheth, appeared today on behalf of the applicants. The next date of hearing in this regard in presence of the applicants is scheduled on such and such. Now, my lord, kindly take the supplementary affidavit. My lord has seen that last order. I just placed it, which is at page 11 in this supplementary affidavit.
Yes.
All the orders are there. That first day order, general power of attorney questioned about, that is at page 10. Then 11, last paragraph, which I just placed from that report. Same paragraph. Then, my lord, kindly come to the next page, 12. As per scheduled date and time, that is on 15th December 2023 at 12:30 p.m. one of the applicants, Sri Tutu Das alias Nirmohi Chaitanya and Sri Pradeep Sheth, appeared in the hearing referred to the order of earlier hearing dated 29th November 2023. It was found that the documents like deed and porcha were submitted by them at our office. When they were asked about LR mutation certificate, the third ploy, first day, power of attorney, second day, to a beyond 20 kata personal presence is required. Then third ploy is LR mutation is required. Certificate that they inform that the said mutation exists in the name of their grandfather, Sri Madhusudan Guho, and they also acknowledge that it has not been yet transferred in their name. We cross-checked the same with Banglar Bhumi portal record and found it as correct. However, it was informed to them that LR mutation is required in the name of applicants, since porcha is also in the name of Sri Madhusudan Guho. In compliance with the requirements as laid down in the Citizen Center 2021. No law is there. Now, I will kindly turn to the come to the page 14. Applicants did not turn up at the scheduled time. However, we waited for them till 12:45 p.m. However, one call came to ward Deputy Assessor Collector from the number such and such in the name of Mr. Pradeep Sheth, authorized person as well as power of attorney for the applicants, and he informed that he is very much ill, and as a result, no one from their side is able to attend the hearing and physical inspection today, and they will inform the same in writing shortly. Hence, the inspection is adjourned today. And the next course of action will be taken once the applicants appear in our office. That is dated 27th January 2024. My Lord has got the date.
Yes.
Yes. So this was stand on 27 January 2024. Then, my Lord, kindly turn to the next page, 15, declaration. They have taken the declaration. Then they have taken the declaration at page 16 regarding 50-50% because of two owners now. It will devolve upon both of them 50-50. Now, my Lord, kindly take the stand of KMC. Now, kindly take the affidavit in opposition on behalf of the writ petitioners to the supplementary affidavit filed on behalf of the respondent numbers 5 and 6.
Yes.
So they were successful to hold that they have got nothing to do with my land. They did not do anything. They did not utilize it. They were successful till then. Now, my Lord, last order, my Lord, I have placed. They asked me to go before the LR mutating authority. Kindly come to that at page 17 of my affidavit. This is the RTI answer that as per overlapping register, initial register for noting of acquisition, requisition, and available case records of this office, required information in respect of plot number such and such, Mouja such and such, jail number such and such, is not involved, RS plot number such and such is not involved in any LA case, but CS plot number such and such is partly affected with a declaration dated such and such. In case of LA rehab, such and such for the settlement of immigrants. Then, my Lord, kindly turn to the next page. This is the order sheet of Land Reforms Authority, the other mutating authority. My lord, on the left hand side, my lord, will find the order date, 2nd September 2024. My lord has got it. Yes. Whereas it appears from the petition that the petitioners have filed petition for recording of his or her their names in respect of the following land schedule as legal heirs of Madhusudan Guho. Date of death 20th April 1983. My lord has got it.
Yes.
Yes. Then Khotian number, plot number, Khotian number, share, everything. Details of legal heirs. 1 Jahangir Das, then Tutu Das, alias, everything. Issue field inquiry. My lord, kindly come to order dated 23rd September 2024. On the left hand side, issue field inquiry notices upon the interested parties, fixing date of inquiry on 30th September 2024. My lord has got it. Yes. Then notice duly served. Then though the date of inquiry was fixed on 30th September, the case is preponed upon on such and such, then mentioning the date of inquiry is scheduled on 27th September 2024. Then issue hearing notices upon the interested parties, fixing date of hearing on 14th November 2024. Notice duly served, service return filed with the case record, though the date of hearing was fixed on 14th November 2024. The case is preponed on such and such, then 6th May such and such. Issue hearing notices. Then kindly come to the last order sheet. 16th May 2025. Manat has got it.
Yes.
Yes. Then at the bottom portion, Amartya Sen Uddan, a park built by KMC, is situated on the scheduled plot. Applicants are not in possession on the plot, hence rejected, not satisfied, and hence rejected due to. So my mutation application, LR mutation application got rejected because this has been utilized as KMC park. Now, turn to the next page, page 20. So they were diligently going ahead with my mutation application, and every time they said, oh, come with this document, come with that document, every date I provided those documents. Now, kindly come to page 20. And kindly recollect, Justice Dotto had categorically asked this question, whether you want to acquire this land. Now, kindly come to page 20. The order of the Honorable High Court is reproduced below in its entirety. Let a report in the form of affidavit be called for from the KMC demonstrating whether the application for mutation submitted on behalf of the predecessors in interest of the petitioners has been considered by the authority in compliance with the order of this court, and also under what authority the signboard has been put up by the KMC in the plot in question. In compliance with the order of the Honorable High Court at Calcutta dated by 22nd August 2023, the department, in consideration of the mutation applied by the petitioners, conducted many hearings dated 19th September, 5th October 2023, then 29th November 2023, then 15th December 2023. Then, due to the previous reasons of unavailability on the part of the petitioners as conveyed to the department over time, the inspection was conducted on 24th June 2024. On a last occasion, I have shown the inspection date got adjourned because I could not make myself available.
Yes.
Where the team of Bodo 11, along with one of the applicants, Jahangir Das, made the spot inspection, it was reported that the vacant land was butted and bounded by iron fence with cement base in blue and white paint. KMC glow sign with Amartya Sen Uddan, KMC written and found at the entrance gate, the front gate facing Raja S.C. Mullik Road was found locked and they entered through the rear gate at the side. In the circumstances stated above, and given the fact that currently KMC is in possession of the instant plot of land since a long time period where various school sports, mela, car exhibitions, etc. are conducted in the public interest, the same is being used as public park since a long time. Entire scenario change. Entire stand change. Then invoking section 343, I'll come to that 343 later on. Then entire section 343 has been stated, quoted. Thereafter, kindly come to the next page, page 21. In view of the law laid down in the subsection 1 of section 343 of the KMC Act 1980, the property shall be deemed to have been vested in the KMC, free from all encumbrances by the operation of law. In view of the provisions of the law quoted above, the application for mutation of unassessed plot of vacant land, 21 kathas, could not be considered, and thus it stands rejected as the same has been vested to the KMC by operation of the law itself. So all along, the stand of KMC now the entire scenario got changed. Once the Eller mutating authority has said, no, you are not in a possession. This Amurtha Uddan is in possession, and that is built by the KMC.
You have completed already.
No, I'll be relying on few judgments.
Yes, fact I understand.
Yes. Now, my lord, kindly come to section 343.
So if you are not feel free today, then you can come.
My lord, kindly keep it a short date, my lord, so that I can.
I'll fix the short date.
My
I have
lord.
already heard the matter.
My lord. আর কতদিন ধরে খেলবেন?
Next Thursday.
Next Thursday. My lord.
Next Thursday.
Next Thursday, my lord.
Lordship, I have fixed it on Friday, my lord, instead of Thursday, because Thursday some difficulties because of other.
Next Friday is the 15th.
15th.
Why see then next the Lordship,
Sir,
next Friday.
Friday.
Friday week, Lordship.
In any day 2 p.m.
Any day, my lord, yes, it could be, my lord, that on Wednesday it could be.
My lord, may I suggest one thing? My lord, if Mr. Ghosh has difficulty, my lord, I'll not stand in the way. My lord, next day I'll be completing my submission. My lord, let it take place on 14th August. My lord, I'll conclude my submission. My lord, I'll take another 45 minutes.
Well, let him then you also fix it up. I don't mind for that, but if I have difficulty, you also accommodate me on that. If he wants to complete it, let him complete it.
আমি কমপ্লিট করে নি, তারপরে আপনি বলবেন। অনেকদিন তো খেলবেন,
বলার জায়গায় রাখছো না।
আমি তো আপনাকে নিতে পারছি না, না আমরা আগে দাঁড়িয়ে গেছে।
কিছু নেই তো। Very well. Better be 20th August, 2 p.m. I can hear out the first matter, 2 p.m. I can hear out both of you.
Mal.
Please take down. Argument on behalf of the petitioner continues. Let the matter appear in the list of 20th August 2025. Specially fixed at 2 p.m.
Mal.
Yes. Next. 1230 matter.
I am for the petition. Statement. আমরা নেক্সট উইক বলে দেবো আমি স্টার্ট করি তারপরে নেক্সট the other matter to
In the second half, I will take up the list.
up to 2 matter.
No, learned counsel said this is a very short matter. I don't
Very
know.
short. I will take
Yes.
only 5 minutes.
He is arguing this submission,
Stop
very
this.
short matter, since 2 days. I could not hear him. Very well. Yes, proceed.
My lord, the subject matter is very simple, my lord. Prayer is only for demarcation of the land. My lord, the things for a moment, one plot, big plot. Lord, the got your lordship, just only, my lord. The plot number 139 is the original plot.
Okay.
The total area of the original plot, my lord, the 1.42 acres. 1.42 acres.
Yes.
Well, in a LA proceedings 418 and 95-96, my lord, the 95 decimal land already acquired. The rest portion has not been acquired. Rest portion is area 47 decimal.
Rest?
Rest 47 decimal.
47 decimal.
Total area is 1.42 acres.
Yes.
Out of 95 decimal already acquired.
47 decimal not acquired.
Not acquired. This sum and substance of the case, we are within the 47 decimal. Well, this lot of persons purchased and subsequent purchaser, it has been held. Now the requiring body is a HITCO. HITCO, my lord, entitled only the acquired position, not the unacquired position.
Certainly not. If only
the
95 decimal was acquired, the
Yes.
rest portion, they have no entitlement.
No. Now the HITCO, my lord, when he started the construction by encroaching the some written land, that is the cause of action arises by way of encroaching the written land.
So what is your prayer in the writ petition?
Prayer only for demarcation. I'm just coming with lordships. Only prayer demarcation. My respectful submission, 47 decimal is the written land. It has been transferred in various ways. Some of the person purchased. My client also, some portion already purchased. Now the question is, my learned friend giving the report, not the opinion opposition has been dealt with. Only the report has been submitted. The wrong interpretation. I annex a document. Which has been another plot holder purchased the land. The land has been, my lord, enclosed. I come before this court. Justice Ghosh, my lord, passed an order for demarcation. That has been annexed in the my writ application. I prayed for the similar order should be passed for demarcation on the land. Learned friend of the filing the report that once demarcation has been held, no demarcation is required. This is the certain sum and substance of the case.
Now, what is the point of the HITCO regarding your property?
HITCO encroaching the property. Encroaching the property, I am not disputing about the acquired portion, but the retained portion, those who were retained land.
Whether your property was retained or it is acquired,
My land is retained land,
not acquired.
not acquired. I am not disputed about this acquired. Acquired has not been challenged, not in disputed about this. I could understand the acquisition proceedings has been done. The sketch map has been supplied to the HITCO. I think, my lord, similar portion, my lord, I got the experience. Several matter has been come before this court. Only this particular plot of land 139. As because about 11 persons purchased, I annexed one document in my petition. Similar order has been passed by Justice Ghosh. I prayed for similar order to inquire into this matter, demarcate this portion. If it is required, cost my putting my cost. Nothing prayer is done, only prayer for demarcation. I do not understand why my learned friend afraid of pending this matter in various type of various objection. I only prayed for demarcation on my cost, since I am the return holder. And why afraid of this? This is the sum and substance case.
Okay.
And no affidavit has been used. Only report has been submitted. I accept it.
Where is the order you have referred? Where is the order you have referred?
Next. Justice Subhra Ghosh.
করেছি দেখিয়েছি এটা তো করাই আছে
Justice Subhra Ghosh orderটাকে পাস হচ্ছে এই তো পেজ annexer P6 page 68.
Yes. What is the sketch map?
Page 68.
Sketch map?
No sketch map.
On
The
the
prayer
report,
order was passed
in the
for
report
demarcation.
there is a sketch map.
No, they have submitted a report, a sketch map. This is not the clear at all. This sketch map, I disputed about this. This is not the proper sketch map. As because, my lord, I have the experience. I went to the field inquiry in terms of the order passed by the Subhra Ghosh. I personally present. The dispute is since pending. This is a one plot, plot 139. And my petitioner name is my Biswajit Ghosh. This is the contempt application is pending before Justice Ghosh.
Yes. For the state.
My lord, it is the case of the petitioner, my lord. The petitioner number 2 and 4 purchased the land. There is no petition. In paragraph number, my lord, 2 of the petition. First point is this, my lord, there is no petitioner number 4. Only আমি একটা short করে চলে এসে ঘরে 3 petitioners is there, my lord. They have, my lord, purchased 3 kata land, plot E, by registered sale deed dated 20th January 2011. And on the same date, my lord, they purchased 1 kata 8 chatak land, plot number C, from 2 persons. Total purchase, my lord, 4 kata 8 chatak. Plot number 139. ভাই ইট ইজ ভাই প্লটের পরে আসছি তোমার গল্পটা তোমার কেসই নেই তুমি বলবোটা কি
আমার কেস নেই তো নাই বলে
মিলাড ওয়ান গায়ান আমাকে আমার মতো বলতে দাও তুমি তো বলেছো মাইলটকে আমি আমার বলিনি মিলাড ওয়ান মনিদাসি ওয়াজ দ্য অরিজিনাল ওনার অফ দ্য ল্যান্ড মিলাড she died on 18th February 79. Thereafter, my lord, after her death, her daughter, my lord, Shivobala Dasi, Menoka Loskar, Shubhabrata are joint owners. They sold a part of the land to several persons and lastly sold to Gopal Chandra Das and Sharat Chandra Das. From Them, my lord, petitioner purchased the land. My lord, said Goyananda, my lord, executed a gift deed in favor of her grandson, Ojoy Mondal Nambokumar. My lord, the said Goyananda, my lord, executed a sale agreement on 18th May 20th May 2011 in favor of Kashinath Nayak. My lord, dear lordship, kindly turn to paragraph 4. Paragraph 4 of the writ petition. That in respect of the portion of the Goyananda Monidasi gift favor, her son, namely Sri Ajoy Mondal, Sukumar Mondal, Ranjan Mondal, and Rambakumar Mondal, all sons of Subhash Chandra Mondal, all executed a sale agreement. It's a millet agreement, not a registered agreement, in favor of one Kashinath Nayak, and Kashinath Nayak paid them consideration amount of such and such. Thereafter, my lord, pursuant to that agreement, that a Kashinath, my lord, constructed a boundary wall on the plot in question. And my lord, that Kashinath, my lord, filed a writ petition before this honorable court. That is case number 6577 of 2011.
The Kashinath.
Kashinath. That the my lord, agreement holder.
Yes.
My lord, 6577. My lord, I am coming. দাঁড়াও না আমাকে দুটো বার করি মাই লর্ডের হাইকোর্টের অর্ডারটা my lord, that matter is pending before this honorable court. It is averment, my lord, from their writ petition, my lord.
Yes.
এটা 6577 এর অর্ডারটা কত বার করো 63 হ্যাঁ পেজ 53 কত 64 ও my lord, page 65, my lord, the writ petitioner is an agreement holder in respect of the land. My lord, what is page 65, annex 5, my lord, High Court's order.
Yes.
By my lord, Justice Arijit Banerjee. The writ petitioner is an agreement holder in respect of the land that has not been acquired and is also power of attorney holder on behalf of the landowners. Accordingly, the grievance of the redress in the land acquisition collector is directed to cause physical demarcation of the land acquired by him, and land still remains with the owners. The land acquisition collector North Chobbish is accordingly directed to cause physical demarcation of the land as stated at once, and such demarcation is made. The writ petitioner will be at liberty to construct a boundary wall such and such, allowing demarcation, physical segregation of the acquired land and from the land not acquired. The physical demarcation will be made by the land acquisition collector in the presence of the parties in the concerned and shall be duly recorded and communicated to the parties concerned. This exercise will be completed within 2 months from the date of communication of the order. The land in the acquisition such and such. Accordingly, my lord, the land acquisition collector demarcated the land in presence of all the parties. Next page, my lord. Page 66. My lord, got it?
Yes.
Report of the physical verification of RS plot number 139. My lord, I think from the top.
Yes.
Report of physical verification of RS plot number 139 of the Mauja Teghoria, jail number 9. PS Rajarat, dated 5th January 2016. In compliance of the order of the Honorable Justice Arijit Banerjee on 10th September 2015, the writ petition number such and such in the matter of Kashinath Nayak versus State of West Bengal. Notice were duly issued and served upon all the interested parties to demarcate physically and acquired area of RS plot number 139, Mauja Teghoria, jail number such and such. The petitioner Kashinath himself was present at the time of demarcation at 12:30 p.m. Sri Shubir Pal, Assistant Land Acquisition Officer, Sri Bivas Bhattacharya, Surveyor of this office, were present with me. And Sri Vikas Chatterjee, Sri Kaushik Chatterjee, both surveyors were also present on behalf of the HIDCO for the demarcation. Demarcation of plot numbers showing the acquired portion and non-acquired portion separately was made up to satisfaction of the writ petitioner in compliance with the order court, and maps in field position making awkward both position yellow colored. And next page, my lord, the sketch map. Therefore, my lord, the plot in question, my lord, is already been demarcated in presence of all the parties. From the Kasinath, my lord, they have purchased this land. It is their averment, my lord. আচ্ছা ওইটা কোথায় দেখাও তো সারেঙ্গিটা না সারেঙ্গি memorandum of agreement. My lord, your lordship, kindly turn to paragraph page 52 P3
52
P3 that is the, my lord, agreement for sale, from whom, my lord, he has, my lord, the taken the power of attorney. This memorandum of agreement is made on this behalf between Kasinath Nayak, son of such and such, as a bina holder negotiator, first part. And my lord, second part, my lord, Suraj Prakash Sarogi. He is no one of the, my lord, the landowner or the erstwhile owners or the predecessor of interest of the main original owners. Therefore, the petitioner has no case. Who is this Prakash Sarogi? My lord, I mean, is the second part, my lord, is the purchaser, Prakash Sarogi. A petitioner purchased the land from whom, my lord? Whereas the negotiator, be the bina holder property mentioned in below by sale of agreement, such and such, executed the original name or such and such, my lord. Therefore, my lord, already, my lord, the land in question is already been, my lord, taken. The land is, acha, এটা দেখতে হবে, কাশীনাথে গেল। And my lord, that writ petition is also pending, my lord. It is stated in paragraph 7. The Kasinath, my lord, who has filed, my lord, is নেই তো কি করে জানবো, সে তো ভাই এখানে লেখা নেই, আমরা তো দেখিনি। Paragraph 7, my lord, they have stated the Kasinath Nayak thereafter made representation before the respondent to stating inter the facts praying for help of construction of boundary wall unacquired portion, but no steps taken. Respondent Kasinath filed a writ petition, and that is pending, my lord. A affidavit is filed, my lord, in that case, my lord. And paragraph 9, my lord, it has stated the Kasinath during pendency of the writ petition to sell an agreement with dated 3rd March 2011 with petitioner number 1 and accepted 10 lakhs in advance with condition to sell deed will be registered upon payment of total land value, but it is not correct, my lord, the annexure P3. P3 is, my lord, the agreement between the Kasinath and Suraj Prasad Sarogi. Therefore, my lord, the averment is totally baseless and, my lord, frivolous.
No, the petitioner has purchased the land from Gopal Chandra Das.
Yes.
What
P1,
they have stated, my lord, in the petition?
Annexure P1. ওটা রেফারেন্স দেওয়া হয়েছে।
The Kasinath already, my lord, taken, my lord, the Babainanama and has made sale agreement. That land has already been, my lord, demarcated by the HIDCO and in presence of the Kasinath, from whom, my lord, he has purchased.
Yes.
Paragraph 9, সেটাই তো বলছি। Paragraph 10 also stated, my lord, the sale deed will be, paragraph 9 has stated agreement such and such with the petitioner and accepted 10 lakhs in advance condition to sell deed will be registered upon payment of total land value, marketable title and such and such, competent court, by check number such and such. P3 is, my lord, says otherwise, my lord. It's a memorandum agreement between Kasinath and Sarugi.
Another portion.
Next pillar, the sale agreement, corporator Kasinath have to deal with the pending with the honorable court. Therefore, my lord, already, my lord, it has been demarcated. And my lord, the HIDCO is in possession. Possession has been handed over to the HIDCO. Therefore, there is no question of my lord, further demarcation. It has already been held and they are in the physical position.
No. Yes.
আমাদের দিয়ে দিয়েছি, report দিয়েছি।
May I submit one thing?
দিয়েছি না?
May I submit?
কিছু বলার নেই। না, ওরা তো হিট ওরা বলবে।
So your submission is that the land was already demarcated by the authority by virtue of earlier order of this
Yes,
court.
my lord. Pursuant to the Honorable Justice Arijit Banerjee's order.
Presence of the Kasinath.
All.
That is the
From whom they have
predecessor
agreement has been held. Taken. Yes, sir.
Lord, I appear for HIDCO, my lord.
Yes.
Lord, I adopt the submission of Mr. Bandyopadhyay, my lord. Only one thing, my lord, kindly comes to page number 73 of writ petition once, my lord.
73.
My lord. Lord, they had earlier filed a writ petition, my lord, which was, my lord, withdrawn, my lord. And no liberty, my lord, was taken to file a fresh writ petition, my lord. Lord, in this regard, my lord, I'll just
73. Who filed this?
My lord, the same writ petitioners, my lord. I have the copy of the writ petition, my lord. I'll produce, my lord. Just be. My lord, kindly takes a look at my lord, paragraph 9 of the judgment, my lord, at the last page of the judgment, my lord. May I place it, my lord?
Yes.
The point for consideration is whether a petitioner, after withdrawing a writ petition filed by him in High Court under Article 226 of the Constitution of India, without the permission to institute a fresh petition, can file a fresh writ petition in the High Court under that article. On this point, the decision in Daryao case is of no assistance. But we are of the view that the principle underlying Rule 1 of Order 23 of the Code should be extended in the interest of administration of justice to cases of withdrawal of writ petition also, not on the ground of res judicata, but on the ground of public policy as explained above. It would also discourage the litigant from indulging in bench hunting tactics. In any event, there is no justifiable reason in such a case to permit a petitioner to invoke the extraordinary jurisdiction of the High Court under Article 226 once again. While the withdrawal of a writ petition filed in a High Court without permission to file a fresh writ petition may not bar other remedies like a suit or a petition under Article 32, since such withdrawal does not amount to res judicata, the remedy under Article 226 of the Constitution of India should be deemed to have been abandoned by the petitioner in respect of the cause of action relied on in the writ petition when he withdraws it without such permission. My lord, this is the copy of the writ petition, my lord. The same petitioners, my lord?
The earlier writ petition.
Earlier writ petition, my lord.
Yes, কি নাম আছে দেখি একটু দেখি
119/21
দেখি একটু দেখি আচ্ছা
সেটা তো আপনারই ফাইল করেছেন আমার কাছে তার কপি নেই আমি জাস্ট প্রেজেন্ট করে দিই একবার প্লেস করে দিই My lord, kindly comes to the prayer portion at page 11 of the my lord earlier writ petition, my lord.
Yes.
And my lord, kindly also, my lord, simultaneously sees the prayer in the present writ petition, my lord. My lord, it has been copied in verbatim, my lord.
Yes.
My lord, I rest my case.
দেখি petitionটা দেখি
Yes, what is your submission?
My lord.
পিটিশনটাকে বের করো বিশেষ May I submit?
Yes.
Lord, the so far my learned friend contention that the matter was earlier withdrawn. That has been categorically stated in paragraph 19 of the read application. As because the representation was not annexed wrongly, that's why matter was withdrawn. Kindly appreciate paragraph 19, it has been dealt with.
Withdrawn to body, no liberty.
So
Paragraph 19 of the writ petition.
as because at the earlier read application without annexing the representation, ma'am, cause of action arises when the encroachment immediately prior for encroachment injunction prior for encroachment. Now the question was arises how the representation was made, the representation was not annexed. That's why matter was withdrawn, and that has been dealt with paragraph 19 of this read application. Now the making the representation come before this court with the prayer for demarcation.
Now, why you not given the, ask for the liberty to file afresh?
No, since my lord, since the representation was not annexed in the earlier read application.
Oh, I understand.
Oh, that
There
is
may
the
be
order
some
has been
technical-
passed. There is an order has been passed, but it cannot be. Merit has been not decided. Merit has not been decided. And apart from that, the subsequent read application with the prayer for demarcation, not only the injunction. Earlier a petition I have just seen only prayer for injunction. So for the encroachment, immediately encroachment has been held by the DITCO. That injunction prayer was made, but the representation was not there. That's why fresh representation was made and fresh read application has been filed. So I think my learned friend submitted, this is the, so far my knowledge, this there is no bar at all. And apart from that, my lord, the plot number 139 is a big plot. Dispute arises relating to the portion of the land has been acquired. Question is only arises when the acquisition proceedings has been done, must have there is a sketch map, what portion has been acquisition, and that has been supplied to the HITCO. Otherwise, HITCO cannot be the recording authority cannot be encroach the property. The dispute arises only things. Well, so far my knowledge, I have done 3 or 4 cases. One case in the contempt application is pending, and by virtue of that order by Justice Ghosh, I personally went to the field inquiry. They have failed to produce the sketch map relating to the acquisition proceedings.
Lord, that has to be produced by the state, my lord. Any allegation against HITCO, my lord, will not do, my lord. That has to be done by the state, my lord.
That is my personal experience I have stated. I am not submitting in such a way. I am personal experience. This has been done. I could understand now the HITCO placed before the court. The portion has been acquired, the sketch map has been acquired, and the sketch map has been prepared by this measurement has been done rightly. I will be out of the court. Now the question is arises, since that acquisition portion, the sketch map is not available, that the dispute arises one after another. My respectful submission, 47 decimal land is the retained land. If it is, a minute, who are the title holder, that will be decided by the competent authority. I am holding.
Why are you arguing on that fashion?
No,
The matter is that once the matter appeared before this court, court directed to make a specific physical
Yes, yes.
inquiry.
Not my
and
client has not come.
whatever may be, the plot is same. So
Plot
the
is
court
same.
directed.
No, plot is same only when
No, no, no.
one
Plot
petition-
is 139.
My lord, appreciate. Only one
Plot
petitioner.
is 139 or not?
139 plot is the one plot is 139.
That's
My respectful submission, when I facing the difficulties, I come before this court, my portion has been demarcated.
so your predecessor has placed difficulty.
No.
He appeared before this court.
No, my
Kasinath-
predecessor has not been difficulties.
Kasinath was your predecessor.
Only, not only that, I purchased twofold. One by agreement of Annexure P3,
so you
Annexure
want-
P1.
No, no, no,
Annexure-
just wait. Let me apprise the entire situation. You want each and every person who purchased the land, their plot has to be demarcated.
This is my responsible submission. When Annexure P1, I purchased the
When
land.
an order was passed by a coordinate bench to demarcate the entire acquired portion,
No,
whether that was done or not.
that has not been done.
So what is your prayer here? In
My
the writ petition,
prayer-
you have not challenged that.
No, that I am not there. I am not there.
You pleaded that,
I
but
am
you have
not-
not challenged this.
I am stated in paragraph. Entire portion has not been demarcated.
You
Only
have
one.
not made any prayer, sir, challenging that
I
demarcation.
made the prayer before Lordship's only thing when I purchased the land, when what portion I have retained the
So
land.
after you sell out the land, your successor will again come.
No.
So you have to challenge the, you pleaded that there is
I
order.
pleaded twofold. One plot I purchased the land, 1%. Another plot I have AOA agreement, Annexure P3.
By time and again, one person who purchased cannot come this court, cannot come to this court.
My lord,
For the same prayer.
So for my little knowledge, about 11 owners possessing the land. More 3-4 cases I have done before this court. 3-4 order has been passed by this court.
Have you challenged this demarcation proceeding?
No, demarcation, my lord. The only thing, one case is demarcation, a contempt case is pending before justice goes. I personally went there. No demarcation has been, fully demarcation has been done. And my lord, these things.
Then why you not challenge the demarcation when you know that?
Challenged in another case. There is the contempt application is pending.
No. Why this petitioner did not?
This
challenge that?
petition, my lord, I a portion of the land, I holding the portion of the land, I prayed for demarcation, my portion. Even I am assumed, I am agreed to make the payment of cost as because so I may be free. I may be free. As because entire thing disputed arises when the acquisition process was done, no demand, no sketch map was there, and the
They have placed the sketch map. You see the report? They have placed a sketch map.
Yes, ma'am, they have this file the report sketch map. Kindly see.
Whether you filed any exception to the report?
Yes. I filed the exception.
Have you challenged the report sketch
Yes,
map?
in the exception I have challenged.
Already specific YOLO marks.
I have challenged.
YOLO marking. Report in the form of evidence on behalf of the respondent.
Kindly see the sketch map. If it is clear, the sketch map, my lord, the acquisition portion I entered the whole HITCO acquiring body.
HITCO was not the acquiring body.
HITCO no, acquiring body supplied the sketch map. That portion has been acquired. HITCO is entitled to get the benefit. And last occasion, HITCO stated the state will.
You, in your exception, you said that the sketch map we are correct.
Correct.
But my portion of the land in RS plot number 130 is not identified
Yes.
and demarcated. So your portion, how can they identify? They can identify the acquired portion only, not your portion.
No, my responsible submission to that respect.
If
I
you
may be-
want your
I may
portion
be
to
wrong.
demarcated,
I may be wrong. My responsible submission, whole things dispute arises one after another only things. The acquisition proceeding was held by the acquisition authority. Requiring body is the HITCO.
No.
I mean, requiring body
No,
is the requiring
HITCO is
body.
not the requiring body. My learned friend is incorrect on facts.
Who was the requiring body?
There was no requiring body. There was no requiring body.
How the HITCO come into picture? How the HITCO come
more
into
research
picture?
should have been done by the petitioner.
That's true. HITCO encroaching the property. That's why.
no, what you want? You are saying that the report and the demarcation sketch map in report are correct, but
Not
your portion of land in RS Dag number 139 was not identified and demarcated.
Lord, the things for that or that demarcation was done by another petitioner, not my petitioner come before this court. Another petitioner, I annex the documents. Order passed by Justice Supra Ghosh and order of Justice Arijit Banerjee.
Look, the order is very specific. Justice Arijit Banerjee said you demarcate the acquired portion and non-acquired portion.
Yes.
This has done
That has
by the
been
authority.
done.
This has done by the authority.
No, now not done. If
So
it is
what,
done,
you must have challenged that. Why you not challenge this?
my lord, kindly appreciate that.
No, the authority concern is directed to demarcate the acquired plot. They demarcated the acquired plot.
That demarcation
and
has
your
not done.
difficulty
If it
is
is
with
done-
the other
my lord,
plots.
if it is done, then why come before this court today? I myself, my lord, the another matter is just your lordship drawing lordship's attention. In my personal difficulty, one contempt case is pending before Justice Supra Ghosh. And that is
that is
in
altogether
respect of
separate
plot
issue.
number
Not, I
139.
am not looking at that.
Hey, দাঁড়াও,
No, no.
তুমি জানো না?
Maybe
আমি
contempt
বলি
applications on other order like that.
139 Biswajit Ghosh. One for same plot. I physically entered, physically went there. মেয়ারলি চিৎকারি করার কথা না, কথাটা হচ্ছে তোমার ডিমার্কেশন তোমার স্কেচ ম্যাপটা দেখাও।
No, they have appended the sketch map.
That is not the correct. You also kindly see if it is understand what sketch map, my lord, it is understand how the sketch map, the acquisition proceedings has been done.
If you cannot understand the
My
sketch
lord,
map,
my
you
responsibility
have to appear before the authority. You have to appear before the authority. This is
So this
new
is not the
construction.
scope. I have no scope there.
Why
I have
you
no
have not scope there?
This was done by another party.
You made a specific representation to the authority.
My responsible submission only things.
You made a specific representation to the authority.
That has been done. Representation last annex representation has been done to demarcate this matter. Representation done.
Look, your plot cannot be demarcated by any authority.
Plot is only one plot.
Your portion, what you have
Since
purchased.
my portion has been encroached. Since my portion has been
What
encroached.
portion do you have you stated?
Yes.
How what amount, what area?
That has been stated in paragraph petition, my lord. That has been stated.
Nothing has been stated so far.
That has been
Have you
stated.
stated?
Yes.
How many portion, how many decimal, how many square feet?
Annexer P1 is the purchase deed.
Purchase deed. I want what portion they have encroached. Have you stated this properly?
দাঁড়াও তিন কাটা।
Okay, today we are out of time, sir.
Yes, come back. For judgment. No, out of
Today.
At 2? Continue.
Today, my lord. Today I have personal difficulties. I have to go into the hospital.
Very good.
কি মাঠে যেতে পারবো না ওই কোর্টে যেতে
Very good.
চলছে
21st.
My lord, second 12:30 matter is my matter, my lord.
I will take up at after 2.
Grateful.
হ্যাঁ
21st বলছেন
কেন চলবে কন্টিনিউ হবে
12:30
I just continue হবে today continue I will continue the release. Let the argument continues. Argument of the parties continues. Let the matter appear in the list on 21st of August 2025 at 12:30.
Can it be 22nd, my lord, subject to
22nd it may be 22nd. Vice. Okay.
হ্যাঁ বলবো তো
But before my lord takes the fixed matter, my lord, item 13, my other side is here, my lord.
You appear for respondent number 1 to 3,
I'm
your
being
lordship.
led by Mr. Dhruva Ghosh, senior advocate. He's not in court today, my lord. May the matter
Item number 13.
13, my lord.
Okay.
I'm to give my reply so far as condonation and restoration is
Taking
concerned.
up item number 13 today.
Yes, my lord. My lord, I'm saying, my lord, my lord, I'm praying for an
On
adjournment.
the list, item number 13. No, is there any other matter to a fixed matter?
Yeah.
That is why I mentioned, my lord, that there's a fixed matter.
Okay, call item number 13 first.
But I am for the petitioner, my lord. I'm praying for an adjournment because of my senior who is not in court today.
What is the application?
I appear for
Application,
respondent
the
number
two
1 to
applications.
3, your lordships.
Two applications, my
You
lord.
are for the respondent number?
Respondent number 1 to 3, your lordship.
Main contesting respondent.
Yes, your
There are two applications, section 5 and restoration, my lord. Since my senior is not here, I'm to give my reply. I'm praying, my lord, that the
Your
matter is
lordship,
kept next week.
yes, your lordship. On the last occasion, they had argued first, and we had placed judgments, your lordship, regarding opposing the condonation of delay, your lordship.
So I'm to give my reply so far as her judgment is
Yes.
concerned. So
I
that,
understand. The application is fixing hearing for day after day.
my lord, I understand, my lord, but
An accommodation is sought for on behalf of the petitioner. Let the matter appear in the list on 14th of August 2025.
14th, your lordship, kindly don't keep it, my lord. Kindly keeps it on 13th or, my lord, 12th. 14th is a very dicey day.
I am only taking these matters Thursday and Friday.
Thursday.
My lord, then, my lord, the next Thursday, my lord.
Why not 14?
My lord, because, my lord, 14th, my lord, there's a
21st.
21st. Extremely grateful, my lord.
Call fixed matter.
My lord, just, my lord, one more indulgence, my lord. May a time be fixed, my lord, so that we can.
No time, no time.
Very well, my lord. Extremely grateful.
Lord, in item number 5, I am for the petitioner, my lord. Lord, before going to the merit,
Interim order was extended. What is the matter?
my lord, matter is, my lord, I have challenged the, my lord, authority as well as, my lord, the violation made by the my state respondent, my lord, by not providing the, my lord, demarcation report. As well as, my lord, I will submit, my lord. There are, my lord, number of, my lord, discrepancies made by the, my lord, state respondent. Now, my lord, before going to the meeting, my lord, I will, my lord, submit, my lord, on earlier occasion, your lordship directed to, my lord, submit the all report and the document directed by the earlier court, my lord. And under this, my lord, direction, my lord, the state respondent was directed to submit, my lord, the gazette notification, and which is required, my lord, in this matter. And, my lord, that was not submitted till the date. Now, my lord, if this matter, if the gazette notification is submitted, my lord, if the same copy may be given to me advance, my lord, so that I can, my lord, argue on that point, my lord.
How can you argue without pleading? Is there any pleading like that? What is the
Yes, yes, my lord, there is a direction.
prayer here?
My lord, the set aside of the order passed by the, my lord, SDM. My lord, that will be, my lord, the violation of principle of natural justice, my lord.
No principle of natural justice.
That will decide by the
He
court.
is illegally occupied the government land. He is stated.
My lord, I will submit, my lord, 4 point, and I will argue on the 4 point, my lord. I need
What
some.
is your prayer here?
Yes, yes, my lord. Kindly see, my lord, page 13.
Yes.
Set aside of the order passed by the, my lord, subdivisional magistrate.
Subdivisional officer.
Subdivisional officer.
Kharagpur.
Kharagpur.
So this order has already been passed. So why you want to set
was
aside
passed,
the order?
my lord, on the ground, my lord, on the 3 ground, my lord. And, my lord, along with that, my lord, the discrimination is made by the state respondent, my lord. The 3 ground is, my lord, first ground is that where the order was passed on the land, my land is different, my lord.
No. So
Second part is, my lord, the authority initiating the action under Highways Act is not appointed under, my lord, the section 5 of Highways Act. That is my point. Third point is, my lord, may I submit, my lord, categorically? That will be, my lord, helpful, my lord,
Who
to
are
achieve
you?
this measure.
Who are you?
Upon me, my lord, the action was taken.
But he is an
Now,
occupier.
Rama, I will satisfy to your.
Kindly turn to paragraph.
Let me complete, my lord.
2.
Yes, paragraph 2 I am reading.
Yes, my lord. The petitioner stated that the petitioner is an occupier of the land. Plot number 208.
Yes.
480.
You are the occupier of the land.
And
How you
that I am submitting, my lord.
Relevant document before the honorable court. He is the owner of the land.
একটা categorically আপনি submit করতে দিন, তারপরে আপনি করুন না.
Yes. So you are the occupier of the
That
land.
point, my lord, I am submitting.
Yes.
And I am, my lord, giving one judgment passed by the, my lord, coordinate bench of this High Court, my lord. Kindly see this judgment. Query of the court, who I am.
What is this?
Kindly take, my lord, page 6.
No, why
The
you
query of the
placing
court,
this
who I am. And I am arguing, my lord, on that point, my lord, what the court query, my lord. I am reading the relevant portion, my lord. Third paragraph, my lord. The question is immaterial whether the occupation is under authority or under no authority granted by the corporation. It's number 6. But the question is whether the action of the corporation in recovering the position by such process can be said to be legal and blessing can be extended by the court. So maybe I am a legal occupier, maybe I am an illegal occupier.
No, what is your stand here? That is not the issue here. What is your stand? Why you file this writ petition?
I have filed this writ petition because the action taken by the, my lord, the authority, saying the authority is not appointed, so there is a lack of jurisdiction.
If the authority has taken any stand or pass any order, how you affected? That's my question.
I have been, the order passed to remove my lord, the shop room.
So who are you? Why you have to here?
I am saying, my lord, I am providing that way the judgment passed by the Honorable Justice, my lord, the Honorable Standard, that the
in respect of this matter?
No, in respect of that matter, but the question, who I am, my lord. Who I am. So this question is irrelevant. That point is settled in 2017. The action, whether I am a legal occupier, whether I am not the illegal occupier, that is the question. That is not the question.
You stated in the writ petition. In the writ petition, the question can
I
can enter into the question after you satisfy
my
this court.
Yes.
You
then my lord, I am an occupier.
You are the aggrieved person.
I am an occupier.
You are an occupier. Yes. Then you say you are the occupier. You don't have any authority to stay, but you are the occupier.
I am an occupier.
Very
but
good.
the occupier, whether illegal or legal, that will be decided by the
Then
court.
you say that I am the
Yes,
occupier.
I am an occupier, my lord.
Very good. Then proceed.
Kindly,
what happened?
Yes,
thereafter?
my lord, the notice was issued under, my lord, section 10 by the, my lord, the Midnapur division, my lord. I have challenged that notice as well as the, my lord, the order passed.
Where is the notice?
Yes.
Where is the notice?
Yes.
Where is the notice? That is your prime challenge.
Prime challenge, my lord, the order passed by the SP.
Very good.
kindly see the, my lord, date.
Page, refer me the page.
21.
Page 21,
First notice was this
21st of September.
21st of September 2022.
Yes. You served with a notice by virtue of an order of a coordinate bench.
Yes, your lordship.
Yes, then
Thereafter, my lord, kindly come to page number 22.
22.
Yes.
What is this? This is the notice under section 10(1).
Thereafter, 23, my lord. Now, I
23.
appear
What is this? 23.
23 issued by the, my lord, subdivisional officer, Kharagpur.
10(1) by the assistant engineer PWD, and thereafter SDO.
SDO. Notice of
23.
hearing, my lord.
Yes.
Now, I have participated with objection.
Yes. You participated there. So where is the order?
Yes.
Order dated?
This is relevant. My lord, the
Page
2nd
26.
December 2022, page number 26. My lord, kindly see the land schedule upon where, my lord, the order was passed. Plot number 418. My lord, can see?
Yes.
My lord, I have stated in the objection also that my plot number is different.
Why you have said that? You have not occupied. So you have not occupied a plot number 418.
No, I am in plot number, my lord. Kindly see page 20, 28. I am in 208 by 418. When the demarcation was made on the land, my lord, no intimation was given. After demarcation, no copy was served upon me. And you lordship know, my lord, that is complete violation of principle of natural justice.
No,
And
they have
my
served
lord,
you notice in respect of plot number 418.
no demarcation notice. What the demarcation was done, that demarcation notice report was not served upon me.
Have you asked for that report?
Yes, my lord.
Why you asked?
I have raised the objection before the SDO.
Where is the objection?
That extent, my lord.
Where
Yes,
is the objection you have raised? Where you have said that?
I'm going. Kindly see my objection and second part, page 2.
Yes, read out.
I further submit that so far the allegation of encroachment of plot number 418 in jail number 713 Mouja Chowk Purushottam is concerned is not true, whereas as per record of land and land reforms of refugee relief and rehabilitation department information, the plot number 418 in jail number 713 Mouja Chowk Purushottam is not part of PWD land.
So you are challenging that
Therefore,
that
the
plot is
allegation
not PW land.
Plot number 1 is that, my lord, the point was raised before the SDO. Now, after that, they have, my lord, the SDO further, my lord, give direction to the BLRO to demarcate the land. Now, I will show, my lord, that part. Now, kindly see their report. The report filed by one Sri Somnath Dottu. Okay.
Statement of facts.
No, no, this is, my lord, the report in form of affidavit.
Report in the form of affidavit.
Yes. Filed by one Sri Somnath Dottu.
Exception to the report. Report in the form of affidavit was ordered.
Somnath Dottu.
Yes.
Page number 8. Kindly see the date, 30th November 2022. After hearing before the, my lord, SDO. May I read?
Yes.
This is to bring your kind attention about the clarification in respect of point D as marked in the letter of Vasudev Raut that plot number 418 as well as 208 by 418, it's same plot and classified as non-usually measuring area such and such of Mouza such and such, jail number such and such. My lord, the relevant portion I have written. So when the second demarcation was made also, no report was submitted. No report was provided to me and the order was passed. Now, to that extent, I will give, my lord, another judgment passed by the, my lord.
So you can challenge their order before the appellate authority.
But there is
No,
an appellable,
I mean
it's an appellable order under section 10(4).
Yes.
I will satisfy
But he
to
has
your
not
lordship. First, give me
availed
opportunity
us
to
not-
satisfy your lordship. Then, whatever
without
your
that,
lordship give
refer to the
direction, I will,
yes,
my
come
lord,
to court,
obey by your.
Okay, okay, okay.
Unless kindly see. This order passed, my lord, by the division bench of this court, my lord. Page number 3.
Yes.
Here, my lord, on similar circumstances, my lord, without providing, my lord, the demarcation report, my lord, the action was taken and my lord, order was passed.
But that
What
is not any
that was-
amendment in the writ petition. No such
I-
amendment. Just taking this plea.
Okay,
Page
just
number
wait,
3.
just wait. Let him finish. Thereafter, I will hear you.
A perusal, page number 3, first paragraph. May I read?
Yes.
A perusal of impugned order clearly revealed that a conclusion has been drawn by the SDO on the basis of report of BLRO Ramnagar 2, but undisputedly a copy of the said report has not been supplied to the appellant. The case of the appellant on merit has also not been considered. Hence, we are of the view that the impugned order has been passed in violation of principle of natural justice. So, two-time demarcation was made and no report was submitted to me. Then how I can, my lord, the raised objection on that ground before the, my lord, concerned authority? May I, my lord, proceed next point, my lord?
Yes.
Yes. Now kindly see section 5 of the, my lord, West Bengal Highways Act 1964.
National Highways Act,
West Bengal Highways Act, State Highways Act.
State Highways Act. State Highway আছে আমার কাছে।
Kindly see section 5, just one. So there must be, my lord, the appointment by, my lord, the state government in publication in the official gazette.
Yes. So appointment by appointment of highway authority.
Highway authority will take action under this act, my lord.
Have you challenged this?
I have challenged.
How can you challenge this?
No, I
Is
have
there any
raised
pleading
the
like that?
before the, my lord.
No, there must have a pleading. If you challenge the authority, then you have
Then
must have.
I will satisfy, my lord. Kindly see, my lord, the my.
Is there any specific pleading? The order
Yes,
passed
yes,
by
yes.
the SDO is without jurisdiction.
Yes.
Yes. Where is that? Where is your pleadings like that? Nothing such prayer is there.
So, but the section 5 is concerned was not taken.
No such prayer. No
But
such
I am on that point, my lord. I am giving another judgment passed by the court on the, my lord, specific query. What your lordship saying?
No, you cannot made by bar that these are the points. You have to plead properly.
My lord,
You are representing a petitioner, not from the bar.
Yes.
You may argue on the point bar from the bar everything.
But the point that I am saying, my lord.
No, this
even-
panel cannot be entertained.
No.
There is
in
no
the-
such pleading here.
I have, my lord, raised this objection earlier that, or my lord, the point.
Have you
was
raised this
taken.
objection in your?
Kindly see the order, earlier order, that order that my lord, the point was taken by the Honorable Justice Subra Bose.
No. In your objection, why
And
you?
on that point, my lord, the direction was given to the state authority, my lord, to submit notification under section 5. That point was already, my lord, considered by the Honorable Justice Subra Bose earlier in this matter. And on the basis of the direction, they have, my lord, produced, my lord, the report.
Only by saying that the person has no authority.
Yes.
Holding the SDO post of
Holding
SDO.
the issue, no, I am saying, my lord, the authority who has taken action under this act, not appointed under section 5. And that point was raised before the, my lord, Honorable Justice Subra Bose in this matter. And
No. I understand your contention, but what is this to be dealt with in this writ petition? Why I shall deal with this?
no, that point I will my lord, satisfy.
There is nothing in the writ petition. Why I shall go into the merit of this matter?
Satisfy to your lordship, my lord. Kindly see.
You have participated before the SDO in the proceeding. Now you are challenging the authority of the
I will satisfy to your lordship.
You must have said there that you have no authority. I shall not participate. After participating there, you cannot challenge that. That from the bar. No.
No, I have not participated in the, my lord, before the authority. For the authority under my lord, the Highways Act, my lord. I have not participated, my lord, before any, not before any executive magistrate, not before any assistant engineer. my lord. I have participated the hearing before the SDO.
Yes.
The authority
And,
under section 3.
and my lord, with objection.
Yes, with objection, I understand, but whether you have
not
objected,
raised
is
that objection before the, my lord, the executive engineer or before the, my lord, the
whether you raise any objection regarding authority of executive engineer before the SDO itself.
I have not raised this objection in pleading, my lord, but this point was raised in this matter earlier, and that was considered already.
That is not the
That
issue.
that
I
was
am
already
here,
considered, and to that
I am
extent they have
hearing the
filed.
entire matter now.
Yes.
You cannot go beyond your pleading.
At that point, I will satisfy you, Lord, sir.
You cannot go beyond your pleading from the bar.
Kindly see this order. Page 3, my lord. Last paragraph. May I read? May I read?
Yes.
There is no doubt that this fundamental legal issue which shall determine the invocation of the provision under the West Bengal Highways Act, under which the step for removal of the encroachment has taken, the law is settled that when a point of law has been urged, even if for the first time in the judicial review, and if the court exercising its power under the judicial review is of the opinion that the point is such which goes to the root of invocation of the particular power under a specific statute, the constitutional court exercising power under the judicial review has vast jurisdiction authority to direct the authority to consider the issue and give its finding with reason and materials.
Yes, that was issue before this court.
So that
was the issue.
So I have
here no such issue is there.
But I have
the pleadings, there is a issue.
But I
that
have,
issue is there.
That I am submitting, my lord. I have not pleaded in the
Then why have I
petition,
said
but that point was considered earlier in this matter also.
I am
Then what
hearing
is
the
this
entire
kind of thing?
no, I am hearing the entire issue. I want to know whether this is issue in this matter.
This
is not an issue.
That was issue was considered only earlier.
No, you cannot pick up any issue beyond the pleading.
But the issue which is
if
earlier considered in the writ petition, how can we?
Interim measures, there may be certain orders.
Yes.
But when I am hearing the entire matter, I should be strict on the pleadings, not beyond pleadings. No, not permitted.
Then my lord, the direction which was passed, my lord, earlier, and report filed to that extent.
That will consider. I will consider at the time of hearing again.
Yes. Now, my lord, kindly see, my lord, my next, my lord, point. My lord, kindly see the order passed by the Honorable Apex Court. Page 13.
Yes.
My lord, under section 5, they have already filed a report. Page 13, my lord. But in these similar circumstances, my lord, this matter was moved before the apex court, but the apex court directed in page number 30 that before acting in pursuance of a road weighting project, the state or its instrumentals must ascertain the existing weight of the road in terms of the official record of map. So, and therefore, in the instant case, when the demarcation was made, this point was taken or not, must be my lord considered.
Whether their state authority is proceeding to widening the road, is there is project like that?
Then no.
Then
they are only basis of allegation made by the my lord.
that is all separate issue altogether. So this is not the widening project of the state.
Yes. So only basis of the allegation when made by the private respondent that their ingress egress is blocking, he cannot use the road highway, and on the basis of the allegation the action was taken. Now my lord, kindly see the page section 8 of the Highways Act. There is a specific bar that a person cannot use a highway without prior permission. Therefore, when the action will be taken, whenever the action will be taken, they must satisfy that the when the action was taken, my lord, the authority must satisfy the allegation made by the any person is justifiable or not. Whether, my lord, I am saying I cannot, my lord, enjoy the highway, my lord, without prior permission. But on the same ground, my lord, no one can enjoy without prior permission of the Highway Act. Highway authority.
What highway for the every public? You can use the highway.
See the section 5, section
Permission to make encroachment.
Section 4, your lordship. Every member of the public has right to use the public highway. Section 4 of the act.
Public right to use the public way, public
Yes.
highway.
Public highway.
Yes, every public can use the highway.
Subject to condition by the authority, my lord.
No.
Yes, my lord. Kindly see.
That is the permission to make encroachment, section 8.
Section 8.
Yes. Section 8 is the provisions for removal of encroachment.
Removal of encroachment.
Yes. So why you are going on the point? What is your point here?
My point is that when the authority will take action, they must satisfy that where I am sitting, maybe I am an illegal occupier, but where I am sitting, that portion is on the my lord highway. And how it will be ascertained? It will be ascertained by demarcation by my lord. So on following the map, the weight of the road. Otherwise, it cannot be ascertained that where I am sitting. If it is I am sitting, my lord, on the my lord highway land, action will be taken under this act. If I am not, if the state authority is not satisfied that I am sitting on the portion which comes under the highway land, then it will be covered by the under the my lord civil code.
Where is your evidence that you are not over the highway land?
That I have given, my lord. I am on plot number 208 by 418.
That is also government land.
My lord, that was demarcated by the state without providing any report.
Show me,
how I can,
show
my lord?
me any document, your possession, LR record,
Yes,
any
my lord.
record.
Yes.
Where is the, have you placed
My
it?
writ petition.
Where is the writ petition? Yes.
Page number 28.
Page number
28.
28. Notification.
28. In the writ petition.
20.
220. Yes.
20. Yes, Development Board Department. Not you.
418. 9.
9 July it is Southern Beverage. That means Development Board Department. It is not your name.
Private land.
It's a government land.
So order was passed on the land of 418.
Whatever may be, you are not occupied there.
No, I am not occupied in 418.
No, you are saying you have argued that you are.
I am on plot number. Yes. So when the demarcation was made, that demarcation report must be provided to me. That then I can, my lord, argue
So
on that
it is
point
your
that
first,
I am,
it is your first point, no report was served upon it.
yes, no demarcation was served upon me.
No
And
report of
without
demarcation.
serving, that, my lord, the action was taken.
Okay, that is only your.
But second point is, my lord, the highway authority not appointed under section 5 of
Very
Highways
good,
Act.
very good. Yes. And third is
That
the,
is, my lord, the what is the weight of the land was not, my lord, given or ascertained by the state authority.
that's all. Okay.
And on the 2 point, my lord, violation of principle of natural justice, and my lord, the lack of jurisdiction, I preferred, my lord, the petition instead of invoking, my lord, the appellate provision.
Lack of jurisdiction you have not pleaded in the writ petition.
But that was considered by the court in this.
Very good. At the time of final hearing, I shall
Yes,
not
yes,
consider. As because there is no such pleading. In the interim measures, you have such report orders like that.
Yes.
But in final hearing, you have to strict on your pleadings. So you have for natural violation of natural justice. When you file the writ petition?
I have filed this writ petition in
It's
2020.
even 23rd February 2022.
14th of December 2022.
Yes.
Yes.
Milord, this petition, Milord, arises from the order passed by this Honorable High Court's order. One Sanchita Malik, Milord, moved the petition before this Honorable Court, alleging this that there exists, Milord, the government land, the PWD department land in front of this Milord residential house, and Milord, the private respondent enclosed a portion of the government land, and for that, Milord, it's blocked the ingress and egress of the petitioner. That petitioner was constitutional. Well, a petitioner himself admitted in paragraph number 2 of the writ petition, Milord, that he is an occupier of plot number 208 plus 480.
Yes.
That page 20A, Milord, the plot information it reveals, that is the annexure of the writ petition. The plot number 208418, going unit.
Yes.
And Milord, top of this, Milord, Rayaternam Development Board Department.
Yes.
That is the PWD department. Therefore, Milord, it is, Milord, the land belongs to the PWD department and petitioner is the occupier. Thereafter, Milord, notice has been issued pursuant to the Honorable Court's order, Milord. Your Lordship kindly come to page 21.
Yes.
Page 21 and section 50. A reference, Milord, order of the Honorable High Court, Calcutta, order number 36, 22nd, Pakistan, government of Pakistan, Procedural ground as per direction of the Honorable Justice Supreme Court, High Court, Calcutta. In the above discussion, you are hereby stating the office member of the executive all deeds and documents in support of your possession over the government land, plot number 47 in front of Secretary and the on-site Delta Road, encroaching government land and bearing date of 6 September 20. Next, below, page 3 below, 10-1 notice has been issued.
Yes.
Page 22. Address to the notice under section 10-1 of the West Bengal Highway Act to Basudev Rao, son of Ganesh Rao. Subject to an unauthorized construction of PWD land, plot number 35 in the district posting on Contact Delta Road in connection with the plate number 13 of order number 32. Therefore, it may the notice has been issued in compliance of the Honorable Court's order. In compliance with the order number 13 of the Honorable High Court, Calcutta, in I serve you notice that you should remove your unauthorized construction over the government land in the district. Contact Delta Road within 15 days from the date of receipt of the dates. Otherwise, administration according to law to house you and the cost of removal of unauthorized. Thereafter, my lord, next page, P4. Another notice under section 10.3 that is issued by the subdivisional officer, Khodam.
Yes.
Whereas when the applicant has been filed before the undersigned Judicial of Encroachment, whereas the High Court has issued direction upon administrative authorities in solemn order passing subjection. You are hereby directed to appear for the subdivisional authority. Accordingly, when a 10.3 notice has been issued, he appeared before the SDO and when the revision order passed, he filed his written objection, but nowhere he has that is accepted filed. Nowhere he has said that demarcation or that clearer or report has been stopped up to him. And not in even in my lord, no averment in the repetition. Therefore, he cannot take such plea in this repetition. But the review order passed and accepted. Whereas the assistant.
Yes.
Whereas the assistant for removal under under section 10. 20. Whereas the Honorable High Court has issued pointing direction. Hearing was held on 6 November 2020. All concerned parties. However, the OP, Basudev Rao, son of Ganesh Rao, he could not produce any document to substantiate his claim on land. Third submission of the there is all record. It is clear the Basudev has a departmental land in unauthorized manner. Hence, it is ordered that the concerned assistant authorized under section of the covered position by way of the group. After use of the officer in charge of the district is also directed to the law of the assistant. Well, this order is appealable order. He has not preferred any appeal. Without preferring any appeal, he stated come before this honorable court. Well, on the ground that this road is not defined as not gazetted as per provision of the Highways Act. And my lord, the authority who has passed, he has no authority under section 10.5. But I am producing.
So kindly direct me to serve a copy.
নিশ্চয়ই দেবো আগে মাইলরকে দেখে মাইলর স্যাটিসফাই হলেই তো হয়ে যাবে তোমাকে কপি দেবো কথাটা ফার্স্ট এখন তুমি কত কথা লিখে দেখুন ফার্স্ট তোমার দেখে না ফার্স্ট এখন থেকে তুই আমার সঙ্গে এসো এখানে চলে এসো আর আলাদা করে দেখা করছি হ্যাঁ 7 টাকা মানে প্লেট 771 number this is the Calcutta Gazette published in all over West Bengal, published on 25th August 2015.
Yes.
Number such and such 11th August 2015. Exercise of the power conferred by subsection 3 of the West Bengal Highways Act 1964. Such and such hearing of the state governor is clear with immediate effect the road and its length as mentioned in column 2 and column 3 respectively of schedule below under the public bus department thereafter the civil Paschim Mendipur Kharagpur division Kontai Belda Road serial number 4.
Yes.
Got it? Therefore, it is declared under section 3, my lord. And my lord, next page, my lord, flap, my lord, you have given, my lord, page number, my lord, 814, 16, my lord, right hand side. Left hand side. That is, my lord, serial number for Kharagpur division, for Kontai Belda Road, my lord, got it?
Kontai Belda Road.
My lord, the executive in the higher authority, my lord, next column, executive engineer Kharagpur division and assistant engineer under Kharagpur division having jurisdiction over the road. Well,
Yes.
before this, I'm reading my lord the above heading. In exercise of power conferred under section 5 of the West Bengal Highways Act, hearing of the such and such, governor is pleased to hereby appoint the immediate effect the higher authority within the meaning of clause B section such and such in column such and such road in the length and the work department name. Therefore, the authority has also been given under section 5. Therefore, the petitioner has challenged the repetition of the frivolous, my lord, allegation. And, my lord, I am referring, my lord, the judgment passed by the, my lord, Justice Jyotirmoy Bhattacharya, the same step for the press. My lord, sorry, my lord, it is been marked, underlined.
Very good. It is helpful.
Second page, maybe. My lord, second page, my lord, I am reading, my lord.
Yes.
Government it has been defined, my lord. Thereafter, my lord, section 3 of the State Act provides that the state government by notification in the official declared pathway, land, highway, these might be in my view, no declaration under section 3 is necessary in respect of the government road, which itself is a highway, independent of any such notification of the constitution of the state act. Since undisputedly, the administration of the encroached part of the land is under the control and the management of the public works department of the state. This court has no hesitation to hold that the encroached part of the land is a part of the highway and as such the West Bengal highway that is applicable to the encroached part of the land. Thus, this court has no hesitation to hold that the authority not exceed this court does not find any as such this court with next is very important. These unlawful encroachers have no right to protect their illegal possession in their encroached land by seeking protection from the court of law against lawful owners thereof. This court permits the petitioner to structure from the encroached land positively the fortnight for the concerned authority under the highway that is to release the second coast and recover position realize the cost of it. But a similar circumstance on the same self road, one writ petition was filed by another petitioner below. That matter lastly went up to the Mutation. This point has been taken, no notification, no authority, and ultimately we have my lord filed before her lordship, and the lordship was pleased to direct dismiss this petition, and my lord that availed my lord to the honorable division bench, my lord, presiding my lord, the honorable Chief Justice and and their lordship my lord affirmed this judgment, directing the authorities to remove this illegal encroachment. And next point, my lord, one point, my lord, they have raised regarding the appointment of the SDU. My lord, kindly pick up my report. They have said that the SDO has no authority, they has not been appointed as per section 24. But I have analyzed my lord, there are state skills.
Page 12 notification.
Notification, my lord. It has been issued by the governor, additional
Yes.
in exercise of the power conferred by subsection 2 of the governor who has been the therefore, there is no my lord, lack of jurisdiction of the any authority, my lord, and this is the position of the government land unauthorizedly, and these, my lord, should be removed immediately and pursuant to the honorable compliance of the honorable court's order.
What is the status now?
Status, my lord, pursuant to the honorable court's there is my lord status quo.
Status quo is maintained.
Now, my lord,
Not
I
taken
will.
step for removal, my lord. আমাকে গেটটা দাও ছবি তুলে নাও ছবি তুলে দিতে
That's all.
I will keep my lord two exception, my lord.
Lordship,
Yes,
I am appearing for private resolution number 6, your lordship.
Yes. What is your submission?
Lordship, I am supporting the submissions made by the state, your lordship.
Yes.
And I wish to add only one thing to that. Your lordship kindly takes up West Bengal Highways Act for once, your lordship. Kindly takes into consideration section 11 of the act, your lordship.
Section
11.
Yes.
I am praying for that the petitioner not only be removed from the illegal occupation, but the entire cost as to removal, to the recovery of land, that should be recovered from the petitioner, your lordship.
Further known by the
submit
report of the PLR concern. The report.
What is the report? Report
of the PLR concern who has demarcated, my lord, at the survey number.
Now you have placed the report with the report.
That is, my lord, annex, but it is further the demarcation all my lord's perusal.
Okay.
That should be served upon me before passing order, so that I can argue. I can take my plea.
It's a comment.
Nothing is there. It is in the report.
My lord, I will submit, my lord, 3 exception made by the, my lord,
yes,
state respondent. Now kindly see the gazette notification produced by the state respondent. May I read, my lord?
Yes.
In exercise of power conferred by Section 5 of the West Bengal Highways Act 1964, hereinafter referred as a said act, the governor is pleased to hereby to appoint with immediate effect the highways authority within the meaning of clause D of section 2 of the said act as mentioned in column 4 of the schedule below in respect of the road and its length under the Public Works Department, Alipurduar district such and such, such and such.
This is Alipurduar. You come to right side.
Yes.
Right side, that
Yes.
was shown.
Same, but the jurisdiction is different, my lord.
Yes, Paschim Mendipur.
Now, my lord, kindly see the road. My lord, the notification, my lord, notification issued by the state respondent time to time on the basis of the road to specify the authority who is covered the, my lord, jurisdiction. Kindly see the division, my lord. Kharagpur division PWD. Now, my lord, see the date of issuing this notification, 11 August 2015. Your lordship got it?
Yes.
Now, my lord, kindly see my exception.
Exception.
Page 16.
That's right. Exception to the report.
That report.
Yes.
Page 16. Kindly, my lord, see the date of notification, 15/5/2017. That is a subsequent notification. Now, my lord, kindly see page 21.
Subsequent notification of what?
For jurisdiction. Jurisdiction of the authority.
What is the jurisdiction of the authority? No, what is
Kindly
this?
read page 21.
What place this? What is this?
My lord,
16?
The authority is Mednapur division and they are providing, my lord, the section 5 notification in the official gazette.
What is
of
this?
Kharagpur division.
Yes,
What are you
right.
saying?
My lord, both
You have rightly said. You have not gone through the notification.
Read the
Yeah, I have
notification.
The Paschim Mendipur district.
Yes.
Yes.
And on, my lord, on 2017, my lord, kindly see, my lord, the exception.
পশ্চিম
আরে আপনি
মেদিনীপুর
দেখুন
থেকে
ভালো করে।
শিডিউল ডিভিশন খড়গপুর।
আপনি দেখুন ভালো করে।
আমি দেখে নিচ্ছি।
No, what is this? What are you saying? Page 16?
Page 16, my lord, 2017 notification.
For what?
Which, my lord, the Kharagpur division, my lord, removed newly created Mednapur division and the road comes under, my lord, the Mednapur division.
You read
And
it.
they are
You read
showing,
it.
yes,
Where you are saying? You read it.
I did. My lord, kindly, that was, my lord, I said, my lord, kindly see, my lord, page 21. Kindly see the road jurisdiction under Mednapur division, PW Directorate. Column, my lord, 5. And they are showing, my lord, the notification of 2025, which show, my lord, the Kharagpur division is the authority.
I cannot understand your submission.
Yes. May I clarify? My lord, there are separate division for each district and the separate road. And that authority will take action under, my lord, with the road is come, my lord. My lord, so far my road is concerned, my lord, from 2017, Mednapur division is the, my lord, the highway authority under section 5. And that must be published in the official gazette as required in the law.
Who are you to say so? You are public encroacher.
আমি সাবমিশন করি আপনি বলবেন
Yes. So,
And-
where are you saying that that this is under the Mednapur subdivision?
That 20, page 21.
Page 21.
Yes.
Road
Column 5.
jurisdiction under Mednapur division.
Yes.
PW Directorate.
So which is true? Mednapur
21
division. The exception টা দেখুন দেওয়া আছে।
21 কার কোনটা এটা কি
Exception আমার exception। ওটা দেখুন সব ডকুমেন্ট গুলো তো তাহলে। Subsequent notification. Good. Page 5 is my road. The page 5, not column 5, page 21. And in page 16, second paragraph, an authority decided by the, my lord, state on the basis of jurisdiction.
Very well. Yes.
Now, my lord, kindly see page 16 at once. Paragraph number, second paragraph. Now, after careful consideration of the matter, the undersigned is directed in the interest of public service that the jurisdiction of the roads to be looked after by a newly created such and such jurisdiction. So my jurisdiction is considered by the Mednapur division. And Mednapur division, my lord, kindly see their report. Kindly see the another report filed by my lord Sri Shibu Bishwas. And in the exception, I have categorically stated that this is a merely departmental notification they earlier submitted and not the gazette notification. And that I have pleaded in the exception. So far, section 5 is concerned.
What report you are referring?
I have, my lord, I am referring now, my lord, the report submitted by one Shibu Bishwas. Shibu Bishwas.
Yes.
Page number 9. My lord, the authority kindly see Executive Engineer PWD Mednapur Division giving notice to the SDO Kharagpur. So the action taking by the Mednapur Division, and they are showing the gazette notification of Kharagpur Division. So where is the, my lord, Mednapur Division notification? Where is the authority? The lordship got it?
Yes. In respect of this matter?
In respect of this matter.
Okay.
And on the ground, my lord, I have prepared this read. Now, my lord, so far the judgment referred by the, my lord, my senior friend, that occupier has no legal right to approach the writ court. My lord, kindly see the judgment I referred, my lord, passed by the apex court. On the, my lord, the end portion, the authority who took the action, my lord, violating the principle of natural justice and without demarcating properly what, my lord, the direction given by the apex court, my lord, the state respondent was directed to pay compensation for the act in question. So that cannot be said that if an illegal action was taken by an authority who have no jurisdiction, merely by I am an occupier, I cannot raise objection, I cannot approach the writ court. And your lordship, my lord, no, my lord, the lack of jurisdiction or the violation of principal national justice, even I have, my lord, the alternative remedy. Even, my lord, there is any dispute made on part of me, now I can approach the writ court.
No, I understand, but whether it was pleaded properly in the writ petition,
I have pleaded some portion, not
then
section,
how
but
can this
section
court
5
entertain?
portion I have pleaded in the exception.
Exception is not the
That is-
pleading. You know that.
That under direction of the Honorable Justice.
Whatever may be in the interim measures, whatever may be the orders like that.
That is the fact.
Then, and whether you have raised any objection before the SDO that no report has been placed on you,
that I have submitted.
You have also not placed anything that you are occupying other land than the.
My lord, I have personally, my lord, participated for my client before the SDO.
No, I know, I don't
And
know.
I am
That is
submit-
not
I
the,
am-
that
I
is your
am- I am-
personal communication. I shall not entertain. I want the pleadings or any document that whether the petitioner has said, I am not occupying this portion, I am
Yes,
occupying this portion. Where you have stated that?
Kindly see the objection.
You
Kindly
see-
see the objection.
Yes, you see that?
In the
Whether you have
petition.
stated that you are occupying other plots,
Yes, yes, yes.
that is not belong to the government land.
I am pleaded it that I am not in plot number 418. I am in 208 by
Where you have
418.
stated this? You see your objection?
Kindly see, my lord, page 24, page 25. I further submit that so for the allegation of encroachment of plot number 418, jail number such and such, Mouja Chakpurushottam is concerned is not true. Whereas as per the record of land and the Land Reforms Refugee Act, the plot number 418, jail number Chakpurushottam is not part of PWD land. Therefore, the allegation of encroachment in plot number 418 in jail number 713 is not correct.
You just deny. Have you
I have
stated
denied that I have denied that I am not encroaching the plot where the action will.
You have just denied
taken.
that no, I am not encroached.
Yes.
But you have not made a specific averment there that is not that like that. Or you have not also made any comment regarding the non-service of report or like that.
No, I have submitted before the authority verbally for non-providing the demarcation report. And that is the reason, my lord, the SDO second time, my lord, directed the BLRO to demarcate. And that demarcation report was not provided to me. And I have given, my lord, the judgment, my lord, passed by this division bench of this Honorable High Court that non-providing of demarcation report is also violation of principle of necessity. That is my humble submission.
Yes.
But if I, my lord, preferred appeal before the authority challenging this order, my lord, then I have, my lord, accepted the, my lord, the authority who, my lord, taken action by, my lord, under majority. That is the, my lord.
No,
ground
that is
for
no, that is
preferring
not the. You can raise every ground there. You can raise each and every ground there on point and fact.
So that point is considered initially. And time to time, from 2022 to till hearing this. And that's why my lord direction was given to provide the gazette notification under section 5.
Okay, please take down. Respondent authority in pursuance to an order of a coordinate bench of this court in WPA number 5374 of 2022 within bracket Sanchita Manik versus State of West Bengal.
And may I take this gazette notification submitted by the state respondent?
You serve a copy.
দুটো পাতা রেলিভেন্ট পাতা দিয়ে দিন। পুরোটা দেবো রেলিভেন্ট পাতা দিয়ে দিন।
পুরোটা আপনাদের কি আছে?
পুরোটা দেবো না
বলুন বলুন।
রেলিভেন্ট পাতা
May I get it?
নো নো রেলিভেন্ট পাতা দেবো।
Sanchita Manik versus State of West Bengal. Its order dated 22nd of July 2022. The respondent authority by virtue of an order. Issued a memo to the petitioner on 21st of September 2022. And directed the petitioner to appear before the chamber of the executive engineer PWD. Requiring the petitioner to produce all deeds and documents in support of his possession over government land bearing plot number 408 in front of plot number 204, Mauja Chowk Purushottompur, under police station Belda in the district of Paschim Medinipur. Full stop. Thereafter, a notice under section 10 within bracket 1 of West Bengal Highways Act 1964 was issued by the Assistant Engineer PWD, Kharagpur Subdivision, upon the petitioner on 29th of September 2022. 29th of September 2022. Full stop. The petitioner, no, full stop. The matter was referred to the SDO Kharagpur, wherein the SDO Kharagpur has issued a notice under section 10(2)/10(3) of the West Bengal Highways Act 1964 for personal hearing of the petitioner. During personal hearing, the petitioner appeared before the SDO in personal hearing and placed his reply to the notice. After hearing the petitioner, the SDO has passed an SDO concern has passed the impugned order on 2nd of December 2022, which is impugned before this court. Learned counsel for the petitioner challenged the order on threefold grounds. Firstly, Firstly, it is the contention of the petitioner that before passing the order, an inquiry was held by the concerned block land and land use officer in respect of demarcation of the land under encroachment. The said report was not served upon the petitioner before passing the impugn order. Thereby, the petitioner was not given proper hearing. Thus, the impugn order suffers violation of natural justice. Secondly, it has been challenged by the petitioner that the concerned authority who served the notice under section 10(1) of the West Bengal Highways Act is not authorized person to issue such notice. On the basis of which it is the submission of the petitioner that, on the basis of which, it is the submission of the petitioner that the proceeding initiated by the authority concerned is without jurisdiction. Full stop. Thirdly, it is the contention of the petitioner that the concerned SDO that is subdivisional magistrate Kharagpur under Kharagpur division has no jurisdiction to pass the impugn order, on the basis of which the order impugned is without jurisdiction and liable to be set aside. Liable to be set aside. Full stop. It is the further contention of the petitioner that he is not the occupier of plot number 418 under Moja Chok Purushottompur within police station Belda district Paschim Medinipur, whereas he is possessing a plot number 208/408 under Moja Chok Purushottompur under jail number 713. It is a contention of the petitioner that by the impugn order, the petitioner cannot be removed. He further submits that being the occupier of the land, the petitioner has every right to challenge the jurisdiction or the authority of the officers concerned who were not engaged to deal with the matter. Learned counsel appearing on behalf of the state authority raised strong objection and submit that the petitioner, being an unauthorized occupant, has no authority to challenge the jurisdiction of the state. jurisdiction of the officer who initiated the proceeding in terms of the order of a coordinate bench of this court passed in WPA 5374. It is the further contention of the petitioner that, further contention of the respondent authority that the officers concerned are duly authorized by notification of the government to deal with these matters under West Bengal Highways Authority Act. Under West Bengal Highway Act 1964. This is the further contention of the state authority that the impugn order is applicable order. Thus, the petitioner should have approached the concerned authority according to section 10 within bracket 4 of the said act, but he straightway appeared before this court only to frustrate the order passed by the learned SDO, passed by the SDO. It is a further contention of the state authority that the SDO has committed no error in passing the impugn order, so the instant writ petition has got no merit. Instant writ petition has got no merit. Next part. Having heard the learned counsel for the parties, it appears that the issue of jurisdiction of authorities who passed the impugn order and initiated the proceeding was before this court during the pendency of the instant matter. This court has issued direction upon the authority to submit the report regarding authority of the officers. The concerned authority has placed the report along with the concerned notifications. The said notifications were subsequently challenged by the petitioner by filing exceptions. Full stop. In deciding the entire matter on merit, it appears that the jurisdiction of the officers passed the impugn order was never challenged in the writ petition itself. There are no pleadings or no prayers before this court to issue mandamus, to issue writ, so that the jurisdiction of the authority can be challenged. However, during the course of hearing of this matter, several documents regarding notification of the government was placed by the parties which are on the record. Full stop. The writ petitions are filed by the parties challenging. Writ petition is filed by the petitioner challenging the impugn order issued by the concerned subdivisional controller on 2nd of December 2022.
It's a subdivisional officer, not controller. I beg pardon of your lordship.
Subdivisional officer, controller, subdivisional officer. Subdivisional officer. It appears that the petitioner has primarily challenged the impugn order with a ground that the order was passed by violation of natural justice. That the impugn order was passed by violation of natural justice. It has been argued specifically that before passing the order, the concerned SDO has inquired the spot through concerned block land and land reforms officer who submitted a inquiry report. But such report was not served upon the petitioner. Thereby, petitioner petitioner's right for hearing was infringed. Was infringed. Full stop. Read petitioner, sorry, এমনি petitioner কর। Petitioner has annexed information of concerned land maintained in the Land and Land Reforms and Refugee Relief Department, wherefrom it appears that plot number 208/18 having classification non-Julie, NAYAN-JULI, NAYANJULI, within court, with non-Julie court. Is a government land. Full stop. The state authority has placed 2 reports to justify their action. Report affirmed by the state authority on 6th of January 2023 contain a report of Block Land and Land Reforms Officer Narayangad, Paschim Mednipur, to Subdivisional Officer Kharagpur, Paschim Mednipur, dated 30th of November 2022. The report of the state authority affirmed on 6th January 2023 contain a report of Assistant Engineer PWD Kharagpur Division I have perused the report. All reports contain the position of petitioner over plot number 408. The report contain report of block land and non-defense officer concerned contain plot number 418 as well as plot number 208 stroke 418 okay. As well as plot number 208 stroke 418 measuring 5 decimal are the same plots. Full stop. It is true that the petitioner was heard by the concerned SDO before passing the impugn order. Full stop. The reports contain merely possession of the petitioner, which in their version is unauthorized occupation. The plot number 418 as well as plot number 208 stop of the 418. Non-submission of the report, not non-service of the reports of the concerned block land and land reforms officer upon the petitioner appears to me not so vital for the petitioner, so that his right of hearing been severely affected. Moreover, during the submission of his reply before the SDO concerned, the petitioner never stated or pleaded that he was possession over plot number 208 of 418, not in plot number 418. Moreover, during the course of hearing, he never asked for any report from the block land and from the SDO concern filed by block land and land reform officer. Thus, the term violation of natural justice, which has its implication to the sky, can only be considered to be affected the right of the petitioner if it appears to be so fatal, that can prohibit the petitioner to raise the defense properly. In the present case, in my view, non-service of the report of the BL and LRO regarding possession of the petitioner over the disputed plot of land has not suffered the petitioner to conduct his case, to demonstrate his case before the concerned SDO. Moreover, to the point of jurisdiction of the authority concerned was never pleaded by the petitioner, but during the course of hearing before this court, the authority of the concerned SDO has already been notified by the government by its notification dated 5th April 2022, as well as the notification for declaring the authority of the Public Works Department concerned under the West Bengal Highways Act 1964 has been properly placed. Full stop. The petitioner has raised some objection regarding the jurisdiction of Mednipur division to conduct the hearing. It is the petitioner that the Kharagpur division is now the authority after bifurcation of Mednipur district from after bifurcation of Jharkhand district from Mednipur district. The matter which was raised by the petitioner before this court is not a part of the issue involved in this matter. Thus, I refrain myself to comment on that point. Full stop. In considering the entire issue involved herein, the petitioner had challenged the impugned order passed by the concerned SDO. It appears that the SDO, the notice under section 10(1) has properly served upon the petition. Thereafter, the concerned SDO issued notice under section 10(2) stroke 10(3) of the West Bengal Highways Act 1964. The scope of hearing was given to the petitioner. After hearing, the concerned SDO is of opinion that the petitioner is under unauthorized occupation over the government land. So the concerned SDO has directed the concerned authority to remove the unauthorized structure. Full stop. I find nothing illegality or arbitrariness on the part of the concerned subdivisional officer. Such order. Full stop. Accordingly, I find no justification to entertain the petition.
One thing just.
Standard petition appears to me not meritorious. Thus, the same is dismissed and disposed of.
My lord, just one thing, my lord.
Yes.
Since there is a, my lord, appellable ground on the, my lord, statute, not kindly give me that liberty to file appeal, my lord. Otherwise, my lord, my right will be, my lord.
Lordship, I strongly opposite. Lordship kindly sees when the order was passed by the SDO. In court says the appeal should be preferred within 15 days from the date of the order passed by 10(3) authority.
If you file this revision, if you file this read within the time, then I can extend you. When you file the read petition?
Just after passing the order.
In the month of February 2022, your lordship. Order was passed in the month of
that order was communicated after
it was filed on 14th of December. February. Huh?
Not just after passing the one order. 2022.
2022.
22.
Whether December or let me.
Not 22 December.
Yes.
Yes.
In December 2022.
Yes. Now just after passing the order. That's your lordship query.
Let me see.
There is no delay, my lord.
What is the improved order?
Order at page 26, your lordship.
26. 2nd of December is the order.
Yes.
Okay.
So, my lord, kindly give me that liberty.
It appears that the order impugned is an appealable order under subsection 4 of section 10 of the West Bengal Highways Act 1964. It has been stipulated in the said subsection that the aggrieved person may approach the concerned district magistrate against the impugned order passed by the concerned SDO within 15 days from the date of passing of that order. In the present case, order was passed on 2nd of February, 2nd of December 2022, and the writ petitioner approached this court on 13th of December 2022. So it appears that the petitioner has approached this court, though under misconception, within the statutory period of appeal, as it full stop, as this court has held that the order is not entertainable in the writ jurisdiction. So I think it necessary that the petitioner should be given a scope to challenge the impugned order before the concerned appellate authority. The petitioner is directed to file a specific appeal if he so wishes within a date of 3 weeks.
3 weeks
from the within 3
And
weeks
my
from
lord,
the date of passing of this order.
This point, my lord,
may that-
I have raised so that I can raise my lord the appellate authority
3 weeks and just
without any observation of
3
this court.
weeks. 3 weeks from the passing of this order. If he কি বললাম বলুন? If he so wishes within a date of 3 weeks from date, 3 weeks from the date of passing of this order, on filing such appeal, the limitation, the point of limitation for filing the appeal should be condoned under section 14 of the Limitation Act. I make it clear that.
And the point, my
though
lord.
this court has next para, I make it clear that though this court has observed the merit of this matter, but the concerned appellate authority shall dispose of the appeal after hearing all concerned
Without observation.
all concerned according to the law, without being influenced by any observation of this court.
Lordship, I beg pardon of your lordship that appeal
Till the time, my lord,
the lordship,
the interim order may be vacated.
and my lord, till the time of
lordship,
filing the
appeal may kindly be directed to be disposed of within a time bound manner, your lordship.
I make it clear that the appellate authority, I'll make it clear, Pradhan, the appellate authority shall dispose of the appeal, within 6 weeks, within 4 weeks of filing the same.
And my lord, till the filing of the appeal, my lord, no action, coercive action may be
The lordship, interim order may be
otherwise,
vacated. Your lordship,
otherwise, my lord,
the
I
writ
will
petition
file
is
the appeal.
dismissed.
Lord, may I? Otherwise, I will file the appeal and they will take my lord
Lordship,
coercive action.
for last 3 years they are enjoying
Kindly give me that protection so that I can file appeal, my lord.
from 2022 they
Lord,
are
till
enjoying
filing the appeal, my lord, maybe my lord, this protection may be given. Otherwise, there will be no purpose for filing the appeal, my lord, and they will take action in the meantime.
appellate authority may consider this, your lordship.
And that I am saying, my lord, till filing of the appeal, my lord, not my lord, just
Lordship, the
till filing of
interim
the appeal.
Hey, need order ten.
Interim order may be vacated.
Lordship, my lord,
Lord.
kindly.
I'm praying.
Just my lord, just my lord, the filing of the appeal, my lord.
Okay.
Just filing of the appeal. Thereafter, my lord, the appeal authority will decide.
It appears that the petitioner is maintaining the possession over the disputed plot of land as this court has directed the petitioner to approach the appellate authority. As this court has directed the petitioner to approach the appellate authority, the interim order passed by this court shall be maintained till the filing of the appeal.
Grateful, my lord.
The interim order, if any, would be considered by the appellate authority on its merit.
Yes.
Yes.
Item number 21.
My lord, one thing, my lord, the
writ petition disposed of.
report
Petition disposed of. Interim applications, if pending, are all disposed of.
My lord, no copy was served upon me, my lord, as your lordship
What
directed.
copy?
My lord, the gazette
What are you
notification.
fighting regarding copies?
Gazette notification.
What are you fighting regarding copies?
I am so much junior, my lord. If the copy was not served, I have served all the judgments
You
copy.
take a copy from him.
Yes, my
He
lord,
has
that was
served a copy.
Lordship, the
that
copy should also be given to us, your
And I
lordship.
am submitting, my lord. I
take the copy, snap, or Xerox, everything. You can take.
Then, my lord, kindly direct my lord, to
No,
start
what
copy.
is the direction? The service is there upon you.
No, that copy was not served upon me.
You have not served.
Yes.
I have given him the relevant 2 pages. He refused to accept.
But no,
Here and now.
all copy given to your lordship. That's why I have.
Why all copy?
Very well, my lord. Very well. I have no
Take your
objection.
relevant
I
copy.
have no objection.
All,
I have no objection if relevant
you
pages.
take your relevant copy.
Yes, yes, yes.
Why for the other
Yes,
districts
yes.
like
Relevant,
that?
relevant copy.
You take the only relevant copy. Moreover, it is
Lordship,
available in the
copies may kindly be also given to us, your lordship.
It is available in the site, I think. No, not available. Not available. So you serve 2 pages of it.
Before your
Lordship,
lordship rises, my
copies
lord.
of the report may also be given to us, your lordship.
Yes.
Copy of the report may kindly be given to us also, your lordship.
What report?
Copy of the report filed by the state, your lordship. Today.
Report is there in the record.
Lordship, copies
Yes.
may kindly be
Before your
given to us.
lordship, my lord, rises, my lord.
Yes, what is
Lordship rises, item number 21, my lord. Well, if your lordship takes it, some preference may be given in the next week, my lord. This is I am suffering since 1975.
item number?
21, my lord. Well, item number 21.
Applications? No.
No, 20 motion, my lord. Well, this is well, the land loser since 1975, my lord. We are serious suffering, my lord. If your lordship kindly give some preference, my lord.
How can I give you preference? There are
Well, already there was a
there are
direction.
applications.
Well, already there was a direction to file affidavit. The state has not filed any affidavit. The only
It has to
point,
file the
well, this is in a straight jacket formula, man. After indoor development, well, whether I'm entitled under 2013 Act or well, old Act. This is the only question. That has to be
No,
decided.
no, I understand your matter is very short. But
Not short, my lord. The facts are
where is
totally.
the affidavit of the state? If that is
They
ready,
never come. Well, lordship knows well much better than me.
if
Well,
they not come, how can I proceed?
well,
against-
but some
Who is
preference.
appearing for them?
Well, last occasion, well, now they have changed probably.
Then how
One
can I?
thing a lordship can do. Well, some
You
upgradation.
mention it. You mention it after service on the Monday. On Monday it would be better.
But only one thing, if some upgradation can be given, so
No
that the matter can be,
upgradation.
my lord.
No upgradation.
Wait, yes.
এরই মধ্যে যেটা ভালো সেটা
ওই দুটো পেয়েছি আপনি